Okay. Ms. Zink, can you hear and see the court?
First, yes, I can, Your Honor.
All right, thanks. This is the Family Law and Guardianship Estates docket. If you're here for a family law case or a guardianship or an estate, you're in the right courtroom. If you're here for something else, you need to go over to courtroom 1. If you have a civil matter, an eviction, car wreck, something like that, go over to Department 1. Family law, guardianship estates, right courtroom. All right, just give everyone that notice, courtroom 1 for anything else. All right, today's docket's being conducted via Zoom. That's the county's new video and telephone conferencing system. Courtroom doors open and unlocked. Members of the public can appear in person or on Zoom. Likewise, counsel of record and pro se litigants can appear in person or on Zoom. If you're on Zoom, you need to keep your microphones muted and your cameras off until your case is called. If we have too many people unmuted at once on Zoom, we get feedback through the system and it doesn't always make as clear a record. All right. That's the WebEx or Zoom announcements. I still say WebEx, old habits die hard. We got a couple guardianship matters. I'm going to take those first before we get into any agreed matters and then the ones that are contested. So the first one is the guardianship of Alicio Villegas V, 22-4-240-13. Anyone present on the guardianship of Alicio Villegas V? Specifically, Joel De Hera, Monica Naya, Alicio Villegas IV. Also, the mother who is Deja Medina. Anyone present? No? Okay, well, we'll set this aside. They can go to the end of the docket. They weren't here on time. They'll go to the end. We'll call it again if they show up, just being a little late. The guardianship of Ashley Gonzalez, 23-4-112-13. Anyone present on the guardianship of Ashley Gonzalez? The year outs, Christopher and Brina, year out. Anyone else present? We have a number. Anyone present on the guardianship of Ashley Gonzalez? No? All right. Well, we'll set it aside and come back to it at the end if they show up. Okay, guardianship of Jorge Cruz Jr., 25-4-88-13. Is that you? Yeah. Yeah, go ahead and come forward. Do you need an interpreter?
Yes.
Oh, we might have to wait. Okay. Just
no,
only because do we have...
The interpreter is present, Your Honor.
Oh, okay, I wasn't sure if you were here or next door first. Then, all right, go ahead and come forward.
Pase, por favor.
Mr. Castillo, could you put your credentials on the record?
Yes,
and we'll go?
Yes, for the record, assisting with this morning's docket, certified court interpreter in the Spanish language, number 10837, Jose Castillo, with an oath permanently on file with the AOC.
This is the guardianship of Jorge Cruz Jr., 25-4-88-13.
Este es el caso de la tutoría de Jorge Cruz Jr., 25-4-88-13.
Okay. Ma'am, can you state your name for the record?
Señora, por favor, ¿pudiera decir su nombre para el acta?
Alma Verónica Cruz.
Alma Verónica Cruz.
You're the mother of the now adult individual and also the proposed guardian.
Usted es la madre de este individuo que se propone que ya es mayor de edad y usted va a ser la actriz.
Sí.
Yes.
All right. Is anyone else present wishing to be heard on the matter? Anyone else present wishing to be heard?
¿Hay alguien más que está presente que quiere ser escuchado en este caso? ¿Alguien más que esté presente que quiere ser escuchado?
No.
No.
I just need to announce for other people.
Se requiere que anuncie.
Anyone else present? *6 to unmute on the phone, unmute button on the app or computer.
Si hay cualquier otra persona presente, por favor, identifíquese estrella 6 por teléfono o el icono del micrófono por la aplicación Zoom.
Ok.
Okay. You didn't expect anyone else to appear, ma'am?
¿Usted no esperaba que otra persona se presentara, señora?
No.
No.
All right. What needs to occur at this point in time? You filed your petition, but we need to appoint a court visitor.
Ok. Entonces, en esta parte del proceso, usted entregó su petición, pero nosotros tenemos que enviar o asignar un visitante del tribunal.
The next person on the list is Noni McNinch, and I will appoint her.
La siguiente persona en la lista se llama Noni McNinch. Yo la voy a asignar a ella.
She will have to get the medical reports from the doctor that indicates the disability.
Ella va a tener que conseguir los reportes del doctor que indica cuál es la discapacidad.
And,
Ok.
and she will also do a investigation to just make sure everything is appropriate.
Y va a hacer una investigación para asegurarnos de que todo sea apropiado.
When that's done, you guys can file a hearing for presentation of final orders.
Cuando se haya logrado eso, se puede pedir una audiencia para presentar las órdenes finales.
Ok.
Ok.
In the meantime, did you get these documents that you filed online?
Mientras tanto, ¿usted consiguió estos documentos en línea, los que usted entregó?
From the Washington Court's website, is that
Eh,
where you
De la
printed
sitio-
out the
del
documents?
sitio web de la Corte de Washington?
Sí, tengo algunas formas que me indicaron que tenía que agarrar.
Yes, and I still have some forms they told me I would need.
Okay. I was going to indicate you will need to file, there's a bankruptcy and criminal background form that'll need to be filled out and filed.
Sí, solo quería mencionar que se tiene que rellenar y entregar el documento en cuanto al registro de antecedentes y de declaraciones de bancarrota.
There's also a guardianship training online class you'll need to make certain that you do.
Y hay una clase de entrenamiento para tutores en línea que va a tener que completar.
But
Okay.
I've signed the order appointing the court visitor, and so Ms. McNinch should be in touch with you within a few weeks.
Pero ya firmé la orden asignando al visitante del tribunal, así que en las próximas semanas ella debe contactarla.
Ok.
Her information is also on the order appointing her. You can check out the file at the clerk's office and write down that contact information so you can contact her if you want as well.
La información de contacto de ella va a estar contenida en la orden, asignándola. Usted puede pedir ver la carpeta ahí en la secretaría y puede apuntar la información de contacto de ella si usted desea.
Ok.
That's it for today. Thanks.
Esto es todo por hoy. Gracias.
Thank you. Gracias.
All right. Do we have any agreed continuances, agreed orders, agreed documents?
Your Honor, this is Barb Black. I have a continuance with Mr. Chadwick on a matter. I don't know if Mr. Decker is here.
He is. He's coming forward. Which
Okay.
case is this?
This is the Fitch matter, 22-3-256-13.
Okay. And so are we doing an administrative continuance? Is that it?
Yeah, for a week, I believe.
Yes, I assume a week is what I heard. Yes.
Just to give everyone a heads up, next week's docket is extremely large.
Oh,
So I just want to let everyone know that. Madam Clerk, I think, how many is on the? 35 right now.
here.
So
Oh, goodness.
I
Mr.
just
Decker,
want to
you can
give,
let Mr. Chadwick know I'd be happy to go out 2 weeks if he'd agree to that.
Yeah, two weeks will work just fine.
Okay. Thank
I'm
you.
just telling everyone kind of in advance right now, if we're pushing things a week, we can do it. But so, all right, this matter will be administratively set over 2 weeks to 6, is that 13?
Yes.
613,
Yeah,
I'm
should-
looking at, yeah, 613. I will put that on the bench copies, put them over in this pile, and matters set over to the 13th. All right,
Thank you, Your Honor. Thank you.
thanks. Any other agreed continuances?
Yes, Your Honor, this is Mr. Hayes.
Yep,
So Mr. Mylonas requested a continuance. He's apparently retaining an attorney. So I have agreed to continue this 1 week.
all right, this is the Mylonas matter 22363-13. I did see the parties had filed an agreed stipulation. It wasn't presented. I printed it out because it does appear to be signed, the stipulation by both sides, indicating they want it set out a week. So I printed that out. I can sign that. This sets it over 1 week. Is that what
Yes.
everyone wants?
Correct. Thank you, Your Honor.
Okay. 30th of May. All right, I've signed the stipulated order.
Thank you, Your Honor.
Thanks.
Your Honor, I had a quick question about a guardianship matter.
Yes.
Did in-rate guardianship of Ziana Lee Herrera get set on today's docket?
Yes.
Okay, no
And
worries.
that is, oh, I skipped that one.
That's okay. It'll
After-
be resolved pretty quickly because I
Yes.
think we need to continue it out.
So I'll call that because we didn't call this one. That was, I skipped over that. But we'll see if any other agreed continuances, agreed orders. Don't everyone speak up at once.
Your Honor,
No.
this is Taylor Schaefer. On the Van Diest matter, we have an agreement on one of our motions. So I don't know if you
Okay.
want to handle that now, but just so you know, we have an agreement on one of the two.
Okay, I'll take.
That's correct, Your Honor.
And we'll take that one as one of the earlier cases. It was a pretty, the issues weren't very involved. They were pretty simple matters. So, all
Thank
right,
you.
let's go ahead and call the guardianship of Ziana Laree Herrera, 25457-13. And do we need an interpreter on that as well?
Yes, Your Honor, just to probably page for the two petitioners.
Okay, Mr. Castillo, if we'll call the guardianship of Ziana Herrera, 25457-13.
Vamos a llamar el caso de la tutoría de Ciana Herrera 2545713.
All right, and are you looking for your clients are the parents, are we polling for them or are we polling for the proposed guardians?
The proposed guardians, Your Honor, they're the ones who would need an interpreter. However, based upon my review of the record, I did let them know that we would likely need a continuance. And so I deferred to them as to whether or not they would show up.
All right, so the guardians are, get to the,
Lydia Herrera Rodriguez and Sergio Noel. Oh, last two names are escaping my memory. I'm
Está
sorry.
Lidia Herrera Rodríguez o Sergio Noel
Banderas Garcia.
Banderas García. Si están presentes, por favor, identifíquense. Estrella 6 si están por teléfono o el icono del micrófono si está por la aplicación Zoom.
Last call for Lydia Rodriguez or Sergio Banderas Garcia.
Última llamada para Lidia Herrera o Sergio Banderas García.
All right. I saw that your clients are in agreement, Ms. Lotstein, but we don't have documents or what's missing.
We don't presently have the DCYF records. In addition, when I was reviewing the court file, it looks like the petitioners just need to sign one additional document relating to their underlying criminal history in that watch report. So I would defer to the court. The court signed an order on April 30th with no date certain for when DCYF needed to provide the documents. So it kind of fell under that. reasonable amount of time
They
parameter.
they filed the background check, the CPS records.
Did they really? I checked yesterday twice and didn't see them.
Well, it's filed under seal, so I don't know.
Oh, I see.
If you don't have access to the sealed side, it may not, but it was filed. The sealed CPS information is in. I do not have the watch background records, but I do have the CPS records.
In that case, we're good to go there. And I would suggest just setting this over the 2 weeks. I understand next week's docket is going to be pretty impressive. If the court would like, I'm more than happy to renote this and reserve the parties. The final orders are done. I will attempt to get the party signatures on that for handing up in 2 weeks.
Okay, I'll go ahead and set it over administratively the 2 weeks. If you have everyone's signed documents and it can be handed up or done ex parte, that's fine. But I'll set it over 2 weeks, and if you need further, it can get stricken if you need more time.
Okay, thank you very much, Your Honor. It's appreciated.
All right, thanks. Set over 2 weeks to the 13th.
Your Honor, this is Victoria
Yes.
Iverson. Were you
Yes.
going to call the guardianship of Jesse Paskey's first, or earlier in
I'm
the
going to call
docket?
that. I'm going to call that later. And
Okay.
are you in the case? You have to either be in or out, Miss Iverson. I've got documents filed in there with you're not signing the petition, but then there's some sealed source documents that on your letterhead that you signed, no notice of appearance. You're either in or out. And if you're
Okay.
in, great. You can say so on the record and you're in. If you're out, then you're out. I'll call that one later because there's a number of issues. There's no service on the wife or
I
the
know.
dad. The mom can't just say the important people to be served are the people that support her side of the version of the events. But we'll deal with that later and see where we're at because, yeah, I wasn't going to take that first. Just, it's not a quick one, I don't think.
All right, sounds good.
All right, thanks.
Thank you.
All right, any other agreed matters? Nope. Then let's go ahead and call the Van Diest case, 19-3-128-13.
Good morning, Your Honor.
Good morning. You guys said you're on for two things, you know, the summer schedule and then the trial setting waiver of mediation, blah, blah, blah. Where are we at? What's agreed and then what's at issue still?
Summer schedule's agreed, Your Honor. I guess I'd leave it to Mr. Schaefer to read into the record, and we can confirm my client and his client are both online. Mr. Heaps, the guardian ad litem, is as well, but we've worked that out and we just need to address the mediation issue and I guess, and subsequently the trial setting.
Okay, perfect. Let's go ahead and put what the I saw you were down to, they were just little minor issues about, you know, exactly when the return dates were and what would include Father's Day or not. So Mr. Schaefer, you want to go ahead and put the agreement on the record and we'll move on to the contested issue?
Sure, Your Honor. So I spoke to my client, Mr. Miller, this morning. I appreciate him being here. I know he's in Hawaii right now. The understanding from my end is that there was this specialist appointment, I think it was podiatrist appointment, that was causing essentially the big hiccup here in scheduling everything. So my understanding is that that appointment is going to get rescheduled. I believe it could be rescheduled into July. Mr. Van Diest is going to get the first half of summer. He is going to begin the summer tomorrow. Brooklyn has a recital tomorrow evening, so he's going to begin the summer right after that tomorrow. He will, during that time of the 6 weeks or so that he'll have, my client will have 5 days where she can visit the children and spend time with them down in Texas, roughly around the midpoint. She's fine with Mr. Van Diest picking the days so long as she gets notice, ideally within the next 48 hours she would like, so that she can, because we're about 3 weeks out from that. That way she can book airfare and plan her schedule accordingly. And then children will be returned on, I believe it would be 1 day past what Mr. Heaps had calculated it. So I think that would be July 16th, but let me double check here. And then they would come to my client. Mr. Van Dies will be up here. He has another child in the Anna Van Dies case. And so there would be an agreement where he could spend 5 days with the children during that time. Again, providing advance notice of the dates and figuring all that out. I'm just double checking right now, Your Honor, on the exact date. It would
The
be
15th was correct.
okay.
it
So
would
the
be
15th. Yeah, so the 16th, Your Honor, they would be returned to Washington. And please correct me if I'm wrong on any of that, Mr. Miller.
I believe that that's accurate. Rob, can you confirm that for us? You can nod. We can see it.
Yeah, that works.
Thank you.
All right. And work for you, Mr. Heaps?
Very much so, Your Honor. Glad to hear that the parties were able to work out the details on their own.
Okay, perfect. The court will order that. The parties put it into the record. If counsel wishes to have a written order, you can prepare one and present it. And if you're good with it on the record, then it's on the record.
Thank you, Your Honor.
I'll leave that up to you guys to, if you want a written order, then get one and we'll go from there. All right. That take care of the summer issue?
Yes.
Yes, sir.
Perfect. All right. Then on to the issue of waiver of mediation and or a trial setting. I saw the materials. So I'll hear briefly from the parties and then I've got a question or two and I'll rule. So
Thank you, Your Honor. It was our motion brought on behalf of Mr. Van Diest, and the court's read the record. It seems fairly straightforward from my perspective. In my experience, relocation matters are somewhat of a zero-sum game. We are fortunate to have an experienced guardian ad litem who is actively engaged in his investigation and working with the parties. I believe it was actually his declaration substantially that was just read into the record as far as what the parties have agreed to for summer scheduling. And with sincere respect to Mr. Heaps, in this circumstance, my expectation is that neither of these persons who very much love and are bonded to their children are likely to agree to a scenario with Ms. Van Diest agreeing to the children moving to Texas, Mr. Van Diest agreeing to the children staying in Washington State, irrespective of what Mr. Heaps is going to be able to produce in his work and his investigation. To my mind, waiving mediation, especially where this isn't the first go around for these parties, as my client points out, they were unsuccessful in attempting to reach resolutions in their original dissolution proceedings. And insofar as those are rather difficult to deal with, relocation perhaps might be even more difficult to ultimately resolve. So from my perspective, it makes sense to go ahead and waive the mediation requirement. If the court grants that request, we would renew our note for trial setting. I appreciated Mr. Schaefer pointing out that we had done so in originally, so we struck that. It's not on the schedule pending the court's determination as to mediations. And looking at the response from Ms. Van Diest, she cites to and attaches several communications where my client had initiated or proposed discussions to sit down as a family to try and resolve the issue about the transition to Texas or not. And she points to that as evidence of the potential for success. But when I look at that, my client, the circled portions of the text messages, the responses are either absolutely not, paraphrasing, of course, or engaging in the unfortunate types of communications that we see, unfortunately, back and forth. I don't think anything about the history of this case, nor prior to the current proceedings, nor the fact that these proceedings relate to relocation signals that there's a likely ability to reach a mediated resolution. We believe the matter should be scheduled for trial at the earliest time possible, understanding, of course, the court's schedules, the party schedules, et cetera. That's our position. That's our request. I'm certainly happy to take questions from the court, but I don't know that I should belabor it anymore.
okay, thank you, Mr. Miller. Mr. Schaefer?
Your Honor, I don't think there's any harm in trying mediation here. I mean, Mr. Van Diest has been reaching out to my client asking if they can sit down, try to work something out. I don't think he would be doing that if he thought it was a zero-sum game, that there was no chance of these parties agreeing. I think often in my experience, and probably from what the court and Mr. Miller has seen, it's the cases that you don't expect will settle at all that often surprise you and end up settling in mediation. And I think when we do have Mr. Heaps here, we have an experienced GAL. Once we get through the summer, once he sees how the summer goes, he'll be seeing the kids with Mr. Van Diest for the biggest block of time that they've had with Mr. Van Diest down in Texas. He'll evaluate from there. Once we get a report from him, I think that will guide these parties as we go into mediation and give us an actual chance at settling. I don't see why these parties would spend all the time and money on trial when there is a chance that once we have a GAO report, they could settle. It's not a case of two parties who can't afford mediation either. Both of these parties are very well off. They can certainly afford a couple hours of mediation to give it a shot. If it was every time that we thought a case couldn't settle because the parties won't agree, we're waiving mediation, you would have a million motions to waive mediation in front of you on every single docket. I just don't think there's any harm in trying. And we could accomplish a lot there. And as far as trial setting, there's a lot of additional work that needs to be done, Your Honor. I think you saw my objection to the trial setting. There's a lot that needs to be done for my client to prepare her case. I understand relocations are prioritized by the court, but my client still has the right to present her case in chief, her case in full before this court at the time of trial. I noted in there my office retained Eric West, an economist. He's going to look at the financial information provided. I understand that Mr. Van Diest may have misunderstood what this is intended for in his response when he said, oh, it's for child support. That's a very minimal part. It's not just for child support, Your Honor. Child support, of course, will be at issue. So the value or the income of Mr. Van Diest is important. But if you remember back when you heard this special set, it was actually special set with the Anna Van Diest case as well, the relocation, there was claims by Mr. Van Diest that his business was failing in Washington and he had to move in order to save his business. But then there were allegations from both Anna and Amy Van Diest at that time that said, no, he was saying that Moses Lake is a hick town and he wanted to leave the hick town where his two ex-wives live. So I think the economics both go to factor 10 in the relocation statute, which is the financial impact of the move, but it also goes to whether this move is in good or bad faith, which is very important for the court at the time of trial to be able to decide. And so we do need that expert to be able to do his work. I imagine that once Mr. West is done, or during that process, I may need to depose Mr. Van Diest's CPA. I may need to get additional information for Mr. West. And I imagine that once I have a report from Mr. West, I would expect that Mr. Miller will probably want to depose my expert as well to get some information from him, figure out where he's at. Additionally, we have Mr. Heaps on this case. I agree he's done a great job so far. I think he helped essentially guide the summer issue here, which also goes towards the fact that we maybe could mediate and settle this, but he's been on this case for about a month. He was appointed at the end of April. We, of course, have to have a report 60 days prior to trial. One of the parties may want to depose him at that point in order to supplement his report, get additional information. We may want to have a settlement conference with Mr. Van Diest. So I just don't think we're ready for trial at this point. I think I saw something from Mr. Van Diest saying that he thinks my client is trying to stall, but that's actually quite the opposite, Your Honor. My client has been trying to move this case along from the very onset. I think we served discovery within a month of the relocation hearing. It was served in either October or November of last year. It finally got fully answered about a month ago. My client was trying to get a GAL on board back when Mr. Lamuska was representing Mr. Van Diest. Then we had a stalling point where Mr. Van Diest changed counsel. It took from November until April until we actually got a GAL on board. My client is not trying to stall this case, but she wants to be able to actually prepare her case for trial. And part of that involves letting the GAL do his work, get his report in, and let these experts work. I would hate to have this trial set a couple months out and then for me to have to come in and ask this court to essentially move our trial, continue our trial, and take away that valuable slot that you gave us for that trial just because we're not ready. And so I think in a month or so, we'll have a much better idea on if we're ready or not. At that point, Mr. Van Diest will have seen the kids down in Texas, understand what's going on here. He'll hopefully be closer to report, and we'll see where we're at. And at that point, we can note it for trial.
Thank you, Mr. Schaefer. Mr. Heaps, anything to add?
I don't think so, Your Honor. I think it's to counsel really to argue the 11 points of relocation. I don't think it would take me long to put on a report that may be of use to the court at trial. It may be beyond the scope of my appointment to weigh in on the mediation matter. I don't disagree with Mr. Miller. There usually isn't a lot of wiggle room in a relocation issue to argue at mediation or to negotiate at mediation. I do believe that this is a case that should resolve quickly. The school year will be around the corner before we know it, and this is something I would hope to see resolved by, the end of the summer. That's probably pretty ambitious. I understand that, but from my perspective, I don't think I'm going to need much more time to give the court what it needs from my perspective.
All right, couple quick questions and then I'll rule. And I know it was stricken as far as the trial setting portion of it was stricken for today, but it does dovetail in with some of the arguments. I have a quick question. How long is this trial going to be? Mr. Miller, you noted it on the trial setting that's been stricken. You said a 4-day trial. Now, is that just for you to put on your case, or is that you're going to put on for a day and a half and Mr. Schaefer's going to put on for a day and a half and there's a, half a day of rebuttal and, and whatnot and it's 4 days, or is that you have 4 days of testimony for you and then plus cross and everything else and we're looking at a 2-week trial? So where do we stand with the number of days for trial, Mr. Miller, and then Mr. Schaefer, just briefly?
My expectation, Your Honor, is that the 4 days would encompass the totality of the presentation of our case in chief, the response, and any necessary rebuttal. And frankly, I expect that we can achieve that in less than that amount of time, but I'm certainly reticent to schedule something and then have a broken up trial where we present testimony and then end up coming back because we didn't have sufficient time. So frankly, 4 days on my end was an expectation of an outlier and would be designed to make sure that we didn't have to come back at some later date rescheduled 6 weeks after the initial presentation of testimony.
So you could do your case in chief in like a day, maybe a little over a day, because there's going to be cross-examined by Mr. Schaefer and Mr. Schaefer's got to have time. I mean, I'm just trying to make sure where we're at. 4 days is, it's a long time, but it's also not. So
I believe we can accomplish our presentation of our case in chief in the day and a half, Your Honor. As far as the cross-examination and duration, of course, I can't control that. That's beyond my capacity, but we believe we can present our case in sufficient time to accomplish the matter in 4 days.
Mr. Schaefer, do you agree this is a 4-day trial for you each to put on your case, each to cross-examine, and each to call any rebuttal that might be necessary, is end time for everything else, any motions in limine and any sort of, the final argument, all that stuff. It's a bench trial, no theatrics, it's the judge is going to hear the stuff and you don't have to cut through, a lot of the stuff can be cut through in bench trials, but do you agree 4 days? Because what's not going to occur is you guys start a trial and then if you get to the end, the judge may strike it if you guys aren't done. I'm not saying that would happen for sure, but there's it's a kind of a little unfair to try to be the finder of fact and then hear other stuff in between and then come back 6 weeks or 2 months later. Mr. Schaefer?
Yeah, Your Honor, I think I probably need about 2 days for my case in chief at my current estimation. So I think we could get it done in 4 days. I think that's probably about right. I think we could probably get it done. If Mr. Miller can get his half done in day and a half, 2 days, I think we can get it done in 4. And when I say 2 days for my case in chief, I'm also including closing argument time in there. I anticipate that I could do a lot of what I would consider my case of chief in my cross-examination of Mr. Van Diest as well. So I think 4 days, we could probably get it done.
Okay. All right. The only reason I ask that is a 4-day trial, isn't going to occur this summer. I mean, a 4-day trial isn't going to occur until next year. Hopefully before the end of next summer is what you're really looking at on any sort of reasonable time frame, especially with counsel having their unavailable dates, that you're going to put in. You can't have trial on these days and whatnot. But so it could get done at, sometime early next year and, stretching in through the end of the school year and maybe even into the summer. So if it's 4 days, that's okay. What I'm going to do is this on the motion. Both counsel are correct. This is one of those cases where two things can be right at the same time. Relocations, when they are cross-country relocations between Washington and Texas, I mean, where are you gonna, it's not like you can meet halfway and we're only gonna move to Wyoming or something like that. It's, you know, the ability to compromise and reach agreements is diminished when it's a cross-country move. By the same token, Mr. Schaefer is absolutely correct that I am amazed at the number and the types of cases that settle, and then some of the ones that don't. The ones you think are going to settle at mediation, they don't. And the ones that you go, there's no way, it's a snowball's chance and you know where that this case is going to settle, and they actually settle. What I'm going to do on the mediation is I'm going to deny the request to waive mediation right now. I'm going to let Mr. Heaps get his report in. I will allow the parties to note up a trial setting without having mediation having yet occurred. I will require, unless a motion is renewed and under other reasons, you know, that to waive it before trial, but I'll allow trial to be set because we are talking about trial out. And Mr. Schaefer, I don't know if you want, it can be, it was already stricken. I could send it to court admin for a trial setting like, you know, after next year. Or it can just, I can just allow the parties to bring that motion back before the court in a couple weeks. I don't know, Mr. Schaefer, if you're opposed to trial setting that would occur. Because again, with a 4-day trial, especially with Mr. Heap's availability, we got 3 attorneys. It's not going to get set until into next year. So is that sufficient time to allow it? You know, that, and mediation can still occur between now and then, but I don't want it to delay. If we wait until, you know, next fall or this coming fall to set trial, it might not get set out until the following fall. So what are the
Your Honor, yeah.
parties?
Well, I didn't mean to interrupt you. I'm sorry.
No, go ahead.
If we are setting it out that far out, I was anticipating that if we were setting trial, it would be set out, you know, a couple months from now, which wouldn't give me time. But if we're setting it out, probably next spring, it sounds like, that is fine. That should give me more than sufficient time to prep with my expert and everything, and we can get mediation done, conference with Mr. Heaps, and see if we can get this thing settled. So I think that's fine.
Mr. Miller, are you fine if I send it to court admin for a trial, a 4-day trial setting today? I'm not waiving mediation. You'll have to do mediation, but you know, trial can get set, and it wouldn't get set until after the first of the year. You'll have to send your unavailable dates. Court admin's probably going to ask for dates starting in like, you know, February of next year with a 4-day trial.
We are fine with whatever accomplishes scheduling trial dates as soon as possible, Your Honor. So if the court is willing to, and we appreciate that, forward that on today. I believe Mr. Schaefer provided his unavailables. Sounds like, unfortunately, not far enough out, but I think the court clerk should have sufficient to start working on it today, and that would be our preference.
And Your Honor, I can supplement those with dates in early 2026. I don't have many unavailables already in 2026, thankfully. So I'll take a look at my calendar and see if I have any trials set or anything like that right now.
We'll do the same, Your Honor.
Perfect. Mr. Heaps, you good with that?
That sounds fine, Your Honor. Thank you.
All right. So I will send it to court admin for a trial setting. I am not waiving mediation, but I'm allowing trial to be set without mediation having occurred yet. That's, you know, in derogation of the local rule, but the court can waive that just so that, because it is a 4-day trial and it's going to be set out a little bit. And so I'll do that. Parties can go to mediation once we have a report from Mr. Heaps. So like I said, I'm kind of amazed sometimes at what actually does settle, or at least get a narrowing of the issues. So, and I will direct that court admin not set trial. I mean, they won't, but until after the first of the year. So if you can send your unavailable dates from the first of the year in, that should give more than enough time. I know Miss Burns I'd already checked with, and she said, you know, we're talking February, March for a 4-day trial. So, and you'll get a couple settings. So, all right. Anything else in the matter?
Nothing for me, Your Honor. Thank you.
Not for respondent, Your Honor.
Thanks. Okay, let's go ahead and take the Marshall and Booley case, 18-3202-8. Mr. Huberto, you're
Morning,
here
Your Honor.
online on behalf of your client.
I am. Good morning.
Good morning. And then Mr. Tony, you're here with your client.
Good morning, Your Honor.
All right, perfect. Any preliminary issues? I think you had some objections to the materials, to some of the hearsay and whatnot. Mr. Huberto, are you fine with the court?
I am.
I use my filter, and I know there's a lot of hearsay that gets put in the declarations. I just jump over them.
Yeah, sure. For the record, there was a lot of material, so I wanted to identify them formally in my objection. Obviously, I couldn't do one to the reply that I got, but there's some additional objections in that. I trust that Your Honor is going to use your discretion, and obviously, you, as you say, your filter as we've known to love and expect. So that'll be fine.
Yeah, that's fine, Your Honor. Your Honor reads lots of family law
I know.
declarations and is very used to filtering.
People
out
always
hearsay.
put in, so-and-so said this, and I'm kind of going, it's not, unless there's an exception to the hearsay rule, excited utterance, something like that, So, Mr. Tony, any other preliminary issues? If not, I have read the declarations. I granted the ability for either side to provide additional information. They did and didn't go too overboard, so I appreciate that. A lot of it was attachments as opposed to 40 pages of declarations having to wade through. I have reviewed the materials, so I'll hear briefly from the parties. We are talking a major modification and not a minor mod. I do want to point out this was not argued or said in the alternative for a major and a minor. So we are talking only about the substantial change in circumstances of the non-moving party. So anything your client, her changes don't matter. It's only of the father and the child because it's a major mod. So
I understand that, Your Honor. The change to the father's circumstances are so closely related to the change in my client's circumstances that they're sort of unavoidable, because what we have is really a change to the whole universe here versus where we were when this parenting plan was agreed to. When the parenting plan was agreed to, my client was at that time charged with domestic violence assault, and I believe was only receiving supervised visitation at the time. And she was unrepresented, and that put her at a very significant disadvantage in the whole negotiations. Since that time, that charge was dropped against my client, and Mr. Bewley was actually charged with domestic violence assault, which eventually resulted in his being convicted of a malicious mischief domestic violence charge. And I have provided the JNS to Your Honor, as well as Your Honor can take judicial notice to any of the court records. You have obviously full reign to do that. So we can see that in 2018, the parenting plan was agreed to. That was during, as I said, the time that she was charged with assault. Then I believe in 2019, he was charged with an assault. And then finally in 2020, that case resolved with him being convicted of the malicious mischief domestic violence. So we have a very large change in his circumstance in that at the time that the parenting plan was entered, the court had no ability to consider the fact that he now has a domestic violence charge on his record. That's a significant portion of any parenting plan is domestic violence and propensity to violence and those sorts of things. So we do have a major circumstance. We also, as the child gets older, have a change in the overall family circumstance, which is detrimental to her, in that as she gets older, it's becoming inappropriate and not to her benefit to either be forced to sleep in a room with, I believe, if I recall correctly, a stepbrother who is a teenager, or the father himself, which is the circumstance that we're currently reaching. As she reaches teenage years, puberty, all those things, she's either going to need privacy, or at least to be in a room with only actual full-blooded family relatives, and preferably of the same gender, for her safety and to her benefit. In addition to that, from what I review of the record, particularly Mr. Bewley's response, is that he seems to be creating a environment of distrust towards my client, who is the mother. They've come up with code words, things like that. And I don't see any particular reason why that would be necessary, except that it appears that he's trying to color the child's perception of my client, which is obviously also to her detriment. The greatest benefit here would be to be spending time with both parents. That's almost always the case, where if we can spend time with both parents, that's to the biggest benefit to the child. But really, the largest change in circumstance that we have here, as I said, is at the time, Mr. Bewley was not accused of any domestic violence. He hadn't been convicted of any domestic violence, and now he has. And the court needs to be able to enter a parenting plan that takes that into consideration.
Okay, thank you, Mr. Tony. Mr. Huberto?
Thank you, Your Honor. I'll try to be as succinct as possible, recognizing that my response was fairly thorough with the objections in the memorandum. Keep in mind that we didn't get a chance to do a response to the reply, so anything new contained in there, vis-a-vis the thing that caught my attention was these allegations that dad's somehow sleeping in the bed with the kid and so forth. We have a 9-year-old little girl between these two parties. That's not something my client had a chance to address, and quite frankly, I don't think it's germane to the issue now anyways. Your Honor put forth the information before Mr. Tony started about how this is a major modification, because in fact it is. We set that the case law within our memorandum, that a major modification requires obviously more than petty siping, as we know as the case law sets out, but also it has to be a substantial change of circumstances with new facts that have arisen since the entry of the parenting plan. And this substantial change has to be based upon the non-moving party, my client, or of the child. So keep in mind the final parenting plan in this matter was entered on June 8, 2018. It gave my client primary custody, and mom has, well, for lack of better terms, a standard every other parenting plan. We use those terms here so the court understands what I'm talking about, the every other weekend. That's been in place since, well, 7 years now, just about. We're coming up on the 7-year anniversary. It is important to note that mom actually agreed to this plan. I know there was some vague allegations in the initial response that somehow my office, or even perhaps myself, spoke to her and tricked her to signing this. Obviously, I never spoke to her. She did, in fact, sign the plan. The plan was entered by agreement of the parties. Regardless, mom's basis, I had to write down the number of bases that I had to list it here to find out exactly what she's claiming. There's got to be 80 pages of documents and declarations that were responded to in here, but she's claiming that the substantial change in circumstances is that my client's home environment is somehow harmful for the kid. And her basis is this folds. My client allegedly provides excessive screen time for the child. She says that this 3rd grader has low grades. My client argues opposite, of course, is the grade. I mean, they don't even have grades at this age. It's 1, 2, 3, and 4, I think, or pass and fail. But that's her basis for the harmful environment. The kid threw away a school project one time, I believe it was years ago, alleges that my client uses marijuana in his home. My client rebutes that in his declaration. There was an allegation about that he yelled at Miss, I was almost said Miss Bewley, excuse me. I think she goes by Marshall now. Miss Marshall in a football game stadium on 2024 or 2023, an argument that occurred in 2022 at a softball game. And then, of course, my favorite is her online research tells her that she needs to be more time with this kid because she's mom. So I can't stress enough that there isn't even one iota, one shred of allegation that's new facts, let alone facts that are substantial, or let alone facts that impact my client or the child. The alleged domestic violence, it's not assault, it's malicious mischief. So we all know the basic concept of malicious mischief is parties get into an argument. In fact, two married couples, or a married couple for that matter, get into an argument. Somehow a coffee table gets cracked, or a door gets cracked, or a phone gets dropped. That amounts to malicious mischief, essentially. That's what he was found guilty of. But the most important part for our circumstances today was these were from facts that were before the entry of the final parenting plan. This was this alleged incident that occurred that Miss Marshall was actually charged of assault with prior to the entry of the parenting plan. So the facts didn't occur after the fact, after the parenting plan. It's not germane to this issue before your honor. So the reason I'm going through and pointing this out is because my client's request for attorney's fees. Normally, we don't make such requests on modification petitions. There's adequate cause, and the adequate cause threshold is high for a reason. It's to prevent litigants from future expenses having to go through mediation, temporary hearing, trials, discovery, and so forth. So in theory, if the adequate cause threshold does its job, adequate cause gets denied, case gets stopped, right? Obviously, the law favors the finality of plans. However, this isn't the first time that Ms. Marshall's done this. She did this back in, I believe, 2021. Almost identical facts. I mean, I'd have to go through it page by page, but the kitchen sink was thrown to it back then as well by Ms. Marshall. A lot of these same allegations. The court denied adequate cause back then. Court denied our request for fees. Court said, we'll let the adequate cause threshold do its job and it put it to an end. And then here we are in 2025. Ms. Marshall does it again. I think the excessive screen time might have been something new, or her online research might have been something new, but this is what she's done. She should know better. Plus, she has competent counsel with her before this court. There's no reason for her to have filed this. It really is frivolous. I look back to when we talked about the hearsay objections and so forth in your honor's filter. I've actually sat in Mr. Tony's chair many times, many years ago, and Judge Spurline in that courtroom would hold up to parties and their counsel and say, hold up the court file and have highlights of all the hearsay and all the things that he was forced to waste his judicial time and effort reading, and was quite mad. And I think your honor is probably too nice to do that, but I suspect you had to spend a lot of time to read all this hearsay and evidence that's not evidence. It's not before the court. It can't be considered by the court. So that needs to be taken into account too when your honor considers our request for fees, because sadly in this situation, I do believe it's appropriate. Having said that, we request that you deny adequate cause so these parties can at least put an end to this process. And I'm happy to answer any questions your honor has, but I think that the response sets forth in pretty detailed, and your honor clearly had an opportunity to review it.
Thank you, Mr. Huberto. Any brief reply, Mr.
Yeah, Your Honor.
Tony?
I'm having trouble framing it. The event that led to the conviction certainly occurred prior to the entry of the parenting plan, but facts have arisen since the entry of the parenting plan that are substantially different. There's no doubt about that. The fact is that at that time, my client was charged with assault and Mr. Bewley was not. The fact is that after the parenting plan was entered, the charges against my client were dropped and charges were entered against Mr. Bewley, and he was convicted of a domestic violence offense. That all occurred after the entry of the parenting plan. So I don't even understand the argument that somehow those facts arose before the parenting plan was entered. They simply didn't. There was an event that occurred, but all of these facts that came from that event actually arose after the entry of the parenting plan. And so there is a substantially different circumstance for my client, but more importantly for the father, who is now convicted of domestic violence.
Okay. All right. So I did review all the materials. The standard for a major modification is quite high. You have to show changes to the non-moving parent or the other child. And you can't include the moving parent in those substantial changes circumstances. You also have to show that current detriment in the home is presumed. You have to show that there's a current detriment in the home and that the presumed harm of changing the parenting plan, there's presumed harm that when you're going to change the parenting plan, that there's going to be harm. And you have to show that the benefits of the change from the detriment in the home currently outweigh the harm that's going to occur when you change the parenting plan. And the mother did file a petition, and she's alleging under C, the child's present environment is detrimental, and under that prong. So here the allegations regard that the child's not excelling in school. That's one of the mom has a number of allegations. The child's not excelling in school. I looked at the report cards. They indicate she's meeting, or working towards proficiency in most areas. There are a few, especially in reading. She seems to be a little behind in reading. Fluency in reading and understanding the ideas were the ones that she had ones on, not meeting expectations and not making progress towards it. But that's just two of them in there. She didn't have really any fours. exceeding expectations, but the vast majority of them were 2s and 3s, either meeting expectations or progressing towards meeting expectations. While that's concerning, it needs to be addressed, but it appears that it has been. From the dad's perspective, he's, involved in the schooling, and so is the mom. And the mom can help with school when she has the time. But the child's not flunking out. She's not being expelled. Mom also indicates dad has embarrassed the child in the past at softball games and at different things. Those are concerning. The court doesn't like stuff like that when it occurs. No parent does, and no child wants to be embarrassed. I think it's kind of a part of being a parent. You're going to embarrass your kids somewhat. But a lot of that is, as I guess I would look at that as petty sniping between the parties. Mr. Booley isn't, doing what he's supposed to do at some of the softball games, and he makes kind of a stink. And Miss Marshall indicates that he knows the rules and he's been informed of the rules, but he's still kind of just thumbing his nose at him. That's not a really good look on Mr. Booley's part, but that doesn't rise to a level of a substantial change in circumstances, nor does it rise to a level of showing that the current environment is detrimental and the change is going to be outweighed. The benefit of changing is going to outweigh the harm of the change. I don't really care about the issues between the new fiance and soon-to-be spouse, I understand, and the dad, just like I don't really care if dad has a girlfriend and mom doesn't get along with her. Unless you're involving the kids in the fights, I don't really care that they don't get along or that they're best buds. It doesn't really matter. Mom also raises some additional concerns about dad's marijuana use. This isn't disputed by dad, but he says he's not using it around the child. I know mom's has some testimony that she says she's seen the pens and stuff that are within reach of the child. It is a little concerning to the court on those things. The court doesn't want the child to have any access to any sort of alcohol or drugs. Parents need to do a really good job of making sure any of that stuff is up and out of their reach and whatnot. But again, I don't have, other than mom's statement that the pens are in the couch and on a table and are accessible to the child, I don't have anything where the child's gotten into the drugs or anything that the dad has been cited for driving under the influence with the kid or has been arrested for drug offenses or anything. The court doesn't condone, it's a legal substance state-wise, setting aside the federal implications. The court doesn't condone the use and in any sort of frame the child to have access to it. But again, with the high burden or threshold, I have a little bit of smoke, but I don't have anything where it's actually impacted the child. Nothing like that. So both counsel are kind of right on the issue of the DV. So it is true, Mr. Huberdeau, that the court can consider facts that weren't known to the court at the time the agreed parenting plan was entered. And so, it's not like just 2018, that's when the old parenting plan was entered, and that the court can't consider anything from before that. If it wasn't known to the court at the time, the court can consider it. However, Mr. Tony, as far as the conviction, so the dad was convicted in 2019 of a malicious mischief third with a DV designation. It's not an assault. It wasn't a physical altercation that he was convicted of. That is something that's concerning to the court, but it was a single event. And the facts on that occurred prior to the entry, I understand, that what transpired after the entry, and the court can consider, I think, all of it because it wasn't known to the court when the court entered the documents. And then after there was a conviction, even though that facts occurred before, the fact of the conviction was after it. The court can consider all of that. But it was a single district court event 5-6 years ago from facts that occurred 7 years ago, and it's not an assault. The kids weren't really involved. I don't have a lot of information, and there's been nothing since then. If there had been 3 more convictions for assault or for domestic violence instances, if dad had been convicted of malicious mischief DV with breaking all of his girlfriend's phones and other items, I don't have any of that. So I'm a little concerned about that incident that happened, but it happened a long time ago and there's been nothing since. So when I get into the analysis of, can the mother show that the child's present environment is detrimental to the child's physical, mental, or emotional health, and the harm likely to be caused by the change in environment is outweighed by the advantage? A single 6-year-old conviction from events that happened 7 years ago, it's just not enough to get me there. When I look at all those things, there's some concern, but it doesn't rise to overcome the case law that indicates the current parenting plan is presumption of that to continue is what's presumed. And it is the mother's burden to come forward with enough evidence to show. She doesn't have to prove her case, but she has to show, and it's a high burden. And everything, even taken as a whole, it doesn't get there because I don't have anything that gets me there. It's all little isolated incidences and things that haven't risen to a level to cause harm to the child or that shows the dad's been a problem or an issue. Now, again, I know the mom's wanting 50-50 or more time. The court can't really consider those. It wasn't brought as a minor mod. The analysis under a minor mod, could be a little different, but it would be limited to just, up to a few weeks of additional time. But that's not pled. And mom's asking for a 50-50 plan, which is a huge change, and I can't find a major modification. So I'm going to deny, for those reasons, the mother's request for a major mod. Mr. Huberto, I understand your request for fees. I can't find that this was brought in bad faith. There are some issues that the mom brought up that are some concern to the court. It's not enough to change custody. I'm not going to change custody, but I can't find that it was brought frivolously or for an improper purpose. Now, all of these matters have been fully vetted. Now, that doesn't mean that if dad goes out and gets convicted of, a sex offense or something, that mom can't bring something back. But if there is further major modifications that don't have new materials, if it's just this, again, I would probably look at having to impose some attorney's fees. Now, if she has new material, then like I said, he's convicted, he's driving drunk with the kids and gets in a wreck and gets cited for DUI. I mean, that's a whole different ballgame. But
I understand, and thank you for the explanation, Your Honor. He is listening into the conversation as well, so it's helpful.
So that's the court's ruling and rationale. I think I have Mr. Tony's.
I provided a proposed order denying adequate cause, Your Honor. It looks like it was filed on 4/28, if that helps, but a bench copy should have came up the same day.
Yep, I have it. So I'm going to strike through the other findings because I'm not finding it was brought frivolously. I'm going to put findings as detailed on the record on 5/30/25, and I'm signing the order. I do hope I saw that the parties have been, there's been some additional time that dad's been given to mom. I want to encourage, any times that the parties can agree to. I hope that can continue. I know there were some other allegations too about the sleeping arrangements. The child's 9. Hope that's going to have to get addressed down the road, but again, none of that rises to the level of a major modification. So, all right, I have signed the order. I do, and just because I'm not finding adequate cause, like I indicated, I hope that the parties can continue to work together. As the child gets older, the child's schedule is going to change, and you're going to have to be flexible and reasonable with each other. So I hope that can continue.
All right, thank you, Your Honor. We'll get a copy from Odyssey for that.
Yeah, there shouldn't be code words, but you guys shouldn't include the kids. It just needs, the parents should discuss and go from there. But, all right, thanks.
Thank you.
All right. Let's take the Gaddis matter, 21-3-245-13. That is Ms. Zink and Mr. Schaefer again, correct?
Good morning, Your Honor.
Morning. All right, Ms. O'Connell, you're here too?
Who is Miss O'Connell?
Isn't she the GAL? No, that was on a different case. Right? You're not on this case, right, Ms. O'Connell? Okay, I'm getting that was a previous GAL on a different case. So, all right, I'll hear from the parties. We're here on adequate cause. I would like to point out we're here on, and Ms. Zink, I wanted to clarify, you're moving under paragraph 4 and 14, right, as adequate cause. You're using, because you reference those sections. You're not moving under a general adequate cause analysis. You're moving strictly under paragraph 4 and 14, and therefore it's limited to what's included in that paragraph 4 and 14, right? Or are you trying to move under a general modification without using paragraphs 4 and 14?
Well, I mean, our pleadings talk about 4 and 14 because I believe my client has complied with what was expected of her there. But I also feel like that checks the box for a general consideration as well.
Okay. I mean, I'm just saying that's a little slightly different analysis, because then you're under the, that's why I was just asking, because what you're asking for, because what's paragraph 4 and 14 limit the minor modification, to addressing, removing the supervised contact restriction and increasing the mother's time up to every other weekend, Friday at 6 p.m. to Sunday at 6 p.m. The holiday schedule and summer schedule may also be addressed at that time, but that's it and not other. But if you're going to move under the general, then you have to, but then you can't rely on rely on the stipulation that the parties stipulate that there's adequate cause to a minor modification. If you've done what's under paragraph 4, you would have to make the general, you'd have to prove. Does that make sense? It's
Yes,
slightly
I
different
understand what you're saying.
because,
Yes.
because if you're only moving under paragraph 4 and 14, then the sole issue is, did mom comply with that? But then you're limited in what can happen and, what can occur at a potential trial. And the argument is kind of limited to, did mom comply with what's under paragraph 4? If you're moving under the general statute, then, it's more open, but you also can't just rely on that stipulation. Does that make sense?
Yes, that makes
'Cause-
sense, Your Honor.
Okay,
Yeah.
so what are we doing here? Because it's a different analysis, and I just want to be clear so I don't get whipsawed and smushed in the middle.
Um, uh, we are moving under paragraphs 4 and 14.
Okay, perfect. Then any other preliminary matters? That was what the court had. All right, then I would ask the parties, some of the other stuff that's in the declarations is a little irrelevant. It really comes down to, has there been compliance with that? And then we'll go from there. So Ms. Zink, I have reviewed the materials. Give me your argument on has she shown compliance with paragraph 4 and 14, and then we'll go from there.
Thank you, Your Honor. And as just one preliminary matter, I did receive new declarations yesterday afternoon that I don't know if the court was planning on relying on those at all, but I would object to including those as SIR replies and information that we haven't had an opportunity to respond to. And I also feel they're irrelevant.
Mr. Schaefer, you really don't get a SIR reply. You put in a response. If we're limiting it to just I don't really, do you have any argument?
No, I'll defer to the court, Your Honor.
All right, I will exclude those SIR replies. The dad did get his full response in and the court considered that. So go ahead, Ms. Zink.
Thank you, Your Honor. And so I wanted to also point out to the court that this parenting plan was an agreement of the parties. This was not based on judicial findings. This was an agreement of the parties that certain threshold issues needed to be addressed, and then there would be an agreement that adequate cause would be met to remove supervision of the visits and give mom Friday to Sunday, 6 p.m. to 6 p.m. on those days. Ms. Gaddis has complied with what was required of her. The easier portion to talk about is the parenting classes. The mother shall
Stop
complete.
you right there for just a quick second. Mr. Schaefer, I didn't really see anything in your materials that contested mom has done the parenting classes. You kind of even concede that she did those. Your argument is that that's all that she really did. But do you concede she met that the triple P type parenting education class?
Yes, Your Honor. Our contention is with the counseling therapy.
Okay, perfect. Ms. Zink, the court will find that she has complied with the parenting education seminar portions. I saw all the materials filed. Mr. Schaefer's client's response kind of concedes that. And he's just conceded on the record. So go ahead and go to the counseling. I'll find that she's met compliance with that portion of it.
Okay, thank you, Your Honor. And I would point out, Section 14 also requires the father to have participated in triple P parenting class and filed that with the court. And perhaps that happened before I was involved, but I haven't seen evidence that the father has complied with that at this point.
And we're not here on a contempt action for either side not having
Understood.
complied with something, so.
Just pointing it
Go
out.
ahead.
I'll move on to what the court has asked me to do. Ms. Gaddis did comply with the requirements about the mental health counseling. She did an intake on March 7th, 2024 with renewed behavioral health in Grant County, which is a reputable longtime mental health provider in your area there. The complete assessment is provided to the court. The recommendation section from the assessment states Kaylee is here because of a court order. The court order says she must continue in counseling until successfully discharged by clinician. The order states she must address the impact of divorce, exposure to conflict and loyalty, forming on children, implementing boundaries, telling the truth, and increasing stability in her life. Clinician can decide if Kaylee needs these things. Kaylee is working on meeting these criteria, but if contraindicated, clinician can determine that. Kaylee was very insistent that she get into counseling to meet the criteria that the father has placed on her through the courts. So from this paragraph, it's very clear that the section of paragraph 4, where it states that the counseling shall address the impact of divorce, etc., is met by the fact that the Renew counselor was given this information, given the court order, and knew the expectations and the kind of the outline boundaries of the expected counseling. So that box is checked. Going through her evaluation, her diagnosis is mild anxiety, I believe. Minimal depression and mild anxiety is what turns up in the mental health evaluation. And then on May 9th, 2024, there's a letter from Renew Behavioral Health. That's part of her medical records, where it states she completed an intake on March 7th. She has been enrolled in mental health services with Renew. She does not meet medical criteria for mental health services, case management, and therapy services. The topics of impact of divorce, exposure to conflict and loyalty forming on children, implementing boundaries, telling the truth, and increasing stability in her life were addressed in sessions. Kaylee will be discharged from Renew due to not meeting medical necessity for services. Now, to me, that checks the box for paragraph 4. I know that Mr. Gaddis doesn't agree with that. However, at that point, it becomes a question of fact for trial. Do we have adequate cause to get to that point? So we can have a trial on the factual issues there of whether or not his opinion of the mental health services is accurate, or these documents that show that she did the evaluation, she did the treatment that was recommended, because that is what paragraph says, be evaluated and comply with treatment as recommended by the clinician. She did those things. Beyond that, controlling what happens in her individual therapy sessions, that's not part of this. And just to reiterate, she also did the parenting classes. There are things that would have addressed all of those topics in the parenting classes as well. And so Ms. Gaddis, she is asking the court to find adequate cause to let her move to what the parties agreed to, that she would get time unsupervised with her children following doing these things that she was required to do. The fact that this is an agreement of the parties, I think, makes this a little bit lower bar to meet in a way. I don't know if lower bar is the right way to put it, but there's a give and a take when you make an agreement. The agreement was she does these things, she gets this time. She wouldn't have agreed to this. She would have taken this to trial if there wasn't an expectation that compliance would result in the agreement that they had set out at the beginning. And I will just add, and this is part of Ms. Gaddis's reply. She does have questions about whether or not this was a smart thing to do, entering this agreement. Her attorney left the practice of law shortly after, suggesting that this was a positive thing for her to do. She
None of
questions
that's
whether or not
none
that
of
was
that's really relevant to
Understood,
the
Your
issue at
Honor.
hand.
The relevant facts are she was evaluated. She did the treatment recommended by the clinician, and she was released from treatment. With that being said, she's entitled to the agreement that the parties struck in October of 2023.
Thank you, Ms. Zink. Mr. Schaefer?
Thank you, Your Honor. Just to clarify for Ms. Sink, SN 328, court file number 328 is my client's triple P parenting class certificate. So just so everyone's aware, he has done that. It was filed on January 10th of this year. We are asking that you deny adequate cause today, Your Honor. I don't think she's met her burden today. Your Honor, you've seen this case many times over the years. I know I've been in front of you many times on this case over the years. There have been a number of issues over the years. We had Heather Lund appointed as the GAL on this case. She was appointed for about 2 years before we entered into this agreement at mediation. And while Ms. Zink is correct that this wasn't based on judicial findings, this was based on a very lengthy GAL report. We had a GAL in this case, Ms. Lund, who thoroughly investigated for over 2 years, and we adopted her recommendations verbatim. Those recommendations included 191 findings for emotional abuse of children and abusive use of conflict by Ms. Gaddis, no dispute resolution provision between the parties because of that emotional abuse and abusive use of conflict. Abusive use of conflict being she calls CPS, she calls law enforcement every time she gets upset about something. My client has major decision making, she had supervised visits only, and that she enroll in mental health therapy for assessment and treatment, and that I will note that it doesn't say follow recommended treatment. It says she shall continue in therapy until successfully discharged by the therapist. This counseling shall also address the impact of divorce, exposure to conflict, and loyalty forming on children, implementing boundaries, telling the truth, and increasing stability in her life. She shall file compliance reports to the father via counsel, which was never done until we got this motion, and shall also file her proof of compliance and completion with the court. The CR2A and this parenting plan shall be provided to the mother's therapist so that the therapist is aware of the scope of therapy. And so when I hear Ms. Zink say that the counselor can decide if she needs therapy on these things, that's incorrect. The parenting plan and the CR2A say she shall have therapy on these things before. We have to remember this is emotional abuse of children that we had a GAL find that she had done. And so what has she done? She has done minimal therapy. She seems that she wasn't exactly truthful with the therapist, or the therapist didn't exactly understand the very broad scope and the implication of what was required to be addressed and the findings against her. I don't think there's any feasible way that any professional therapist would discharge her after what appears to be maybe a couple sessions with that very broad scope and the finding of emotional abuse of children. Now, she comes back in reply and says, well, I've done multiple sessions, but we don't really have evidence of how many she's done, what she's actually accomplished in these. We have this letter from Renew that says she did an intake on March 7th, I think it was, and that she doesn't meet medical criteria for mental health services. And so we look at the intake forms and you see that, of course, she checked that she doesn't have these issues on the intake forms. So, of course, when you're checking, I don't have depression, I don't have suicidal thoughts, I don't have all these kinds of things, of course, a therapist is going to say you have no medical need or don't meet medical criteria for mental health services. And so that's probably why that's in there. But notably missing from the letter is how many sessions she did, what kind of progress she made. We didn't get a single progress report as required through the parenting plan, so we have no idea what kind of progress she made, what she did in these sessions, what behaviors she addressed, or how in-depth they actually went on these topics, loyalty forming on children, the impact of divorce, exposure to conflict, implementing boundaries, telling the truth, increasing stability in her life. We have very serious findings. I just don't think that she can possibly come here with a straight face and say, okay, I went in one time for an evaluation and then I have a letter that doesn't even really outline what I did in therapy, but I want you to jump me straight to unsupervised time when I have a finding for emotional abuse of my children right now. Not to mention that she hasn't even seen these kids in 9 months. You may recall we were here last fall, I think it was last August, talking about a change of supervisor. Ms. Gaddis fired Fulcrum. She didn't want to use Fulcrum anymore. She requested Spokane Family Guidance to be named as the supervisor. As you probably recall, we spent a lot of time talking about that issue at the time. I told you my issues with Spokane Family Guidance, how many commissioners in Spokane County have issues with them because they're inappropriate, they overstep into a therapeutic role and act as a counselor. And what you ended up ruling, Your Honor, is that she could do her visits there, but they could not do any sort of therapeutic component with that. And so did she do those visits? No, not a single one. She hasn't had a single supervised visit with these kids since August 9th. She hasn't seen her children in 9 months. She comes back on reply and tries to downplay it. She says, it's been a few months since I've had supervised visits because I can't afford it. I was homeless for a while. It's not a few months, Your Honor. It's almost a year. We have 9 months without her seeing these kids. And so it's clear to me that she wanted that therapeutic overstep from Spokane Family Guidance. And so I don't think she's complied with this treatment provision, so there's no basis for adequate cause. We just don't have enough information at this point. If we had a letter from the therapist saying, oh, I met with her 10 different times, and in session 1, we went through this, and in session 2, we went through this, that's what we would normally expect to see in a case like this, where we're talking about putting someone back into a home unsupervised with children when they have a finding for emotional abuse of children and abusive use of conflict. We have no progress reports, no further information except for a 3-line letter that says, yep, I met with her and she did some treatment and I discharged her. There's nothing here. And so I think that adequate cause needs to be denied on that basis alone. I mean, we entered into these by agreement based on the GAL report. She needs to do more than just try to check the boxes. She has to show this court that she won't continue to emotionally abuse the children. And so I think it does need to be denied at this point. But I think even if she has met the requirements, there's no reason to jump her into unsupervised time like she says. I will note the parenting plan does not say she automatically gets that every other weekend schedule. It says she can file a modification. The parties will agree if she's met this, that there's adequate cause, and that she can get up to that every other weekend schedule. And it would be ludicrous at this point to jump her into unsupervised time when she hasn't even seen these children for 9 months. There's no visit for 9 months. She hasn't done a single supervised visit, and she wants to jump right into an every other weekend schedule. My client tells you this is the first time in the children's lives that they've actually been doing well, that they're doing well in school, and he doesn't want this to get screwed up for them.
Yeah, but that's not really an issue.
Well, Your Honor,
right
I think
now.
it goes to if you find adequate cause, she's asking you to adopt a temporary parenting
Oh,
plan.
I know. Don't. Yeah.
And so it goes to what the temporary parenting plan is. And so in her proposed parenting plan, she's asking you to grant 3 weekends a month from Friday to Monday.
We're not going there yet. We got to first find adequate cause,
Okay.
and the court generally, absent extraordinary circumstances, we don't change things until trial. But
Okay.
Ms. Zink, any brief reply and then?
Yes, Your Honor, just briefly. My client's reply declaration explained that she was injured at work around that time, August. She was on leave and not able to make any income, and she simply couldn't afford the hundreds of dollars per session that it was for the supervised visitation. That was explained thoroughly in her declaration. This is a matter of finances. She doesn't make a lot of money. She is paying child support. We provided that proof to the court, which is relevant because it goes to credibility of Mr. Gaddis, who said that she hasn't paid child support in a year. We provided a pay stub that shows she's been consistently garnished. She was off work for a while being injured, but aside from that, she has been paying child support. So that comes out of her paycheck on top of paying for and it is for 8 hours at about $50 an hour. That's expensive. It's not a small amount of money for the supervised visitation. So that's a barrier and a burden to be able to spend time and see your children. But I think that the important thing is here, the bar is being raised from what's actually was put into the agreed parenting plan. And Mr. Schaefer repeatedly said findings, findings, findings. This was an agreed parenting plan. This is not judicial findings. The guardian ad litem report can't be taken at face value when it hasn't been litigated. There hasn't been any witness testimony or cross-examination on it. This is supposed to be a lower bar because it's by agreement. She did check the box that was required of her. She got the evaluation. She got the clinician's recommendations about counseling. She did do counseling that was required of her. Now to say that we need all these reports and we need to see what happens at each and every session, that's not what's required. That's not what's in the parenting plan. And frankly, that would be a real invasion of someone's privacy in the mental health counseling setting to expect that they're going to see counseling notes from every session. That would be arguably inappropriate, and it's not in the parenting plan that was needed. So we are asking the court to see that the bar has been met for what was agreed to, and allow this case to move forward with adequate cause for a minor modification as the parties agreed.
Okay. The only real question I have is it says at the last sentence of the second to last paragraph on section 4. It says the CR2A in this parenting plan shall be provided to the mother's therapist so that the therapist is aware of the scope of therapy. So it is quite clear that the parenting plan was provided to the therapist because the therapist in the notes quotes directly from the parenting plan. I am unclear on whether the CR2A agreement was also given to the therapist. Ms. Gaddis's declaration just states that documents were provided to the therapist, and the therapist notes that are filed under seal indicate that court documents were given and reviewed. And like I said, I have no doubt that the parenting plan was provided. Mr. Schaefer, you didn't really address the issue of the CR2A. Is there anything else? Are you alleging that mom didn't supply the required documents to the therapist?
As I'm looking through these, I mean, it wasn't an initial argument of mine in my argument a moment ago, but as I'm looking through these, I don't see anywhere that the CR2A was mentioned. I do see quotes from the therapist saying that she had Miss Gaddis read the parenting plan either, but I don't know, and maybe I'm just missing it, where the therapist actually reviewed the copy of the parenting plan themselves rather than just have Miss Gaddis read it to them. And I think that might be where the confusion from the therapist came that I pointed out.
Ms. Zink, your client's declaration does indicate that she provided documents, doesn't specify which ones. Was the CR2A given?
Your Honor, I don't know that I have the information in front of me to answer that accurately. I think the appropriate thing would be potentially to leave this open and let us get more information from the therapist to confirm that she received the CR2A agreement. Although I do feel like that's a little bit of a, what's the word? A little bit of a detail that's perhaps not important when the parenting plan lays out everything that is in the CR2A, because that's how they came to the parenting plan, was through the CR2A. So
Mr.
it should be the same information in both.
Mr. Schaefer, is there anything material in the CR2A that isn't in the parenting plan?
I'm trying to find a copy of the CR2A in my file right now, Your Honor. Give me just a moment.
Sure. And then, Ms. Zink, I do want to just inquire while he's looking that up. Your client is wanting to move forward with the material that's been provided to Renew or provided from Renew. I mean, it does indicate that even if there's been compliance and a minor modification can move forward at trial, you know, the amount and type of the counseling would be relevant. Your client's wanting to move forward, correct?
Yes, Your Honor.
Okay. Mr. Schaefer, anything in that CR2A that is materially relevant that's not in the parenting plan?
I am looking at it right now, Your Honor. I mean, it's relatively, I can read it for the court if you would like, Your Honor. It's a little bit longer than what we have. Would you like me to just read the couple paragraphs
What
right
I'm
here?
kind of asking is there anything materially in there that isn't covered in the parenting plan?
Your Honor, the language is generally the same in the CR2A, and then it expands, I mean, ever so slightly, but it's generally the same as in the parenting plan.
Okay, because it didn't require like a giving of the GAL report or anything like that. So, all right. Well, I looked at everything. I listened to counsel. This is on kind of a limited issue on has there been compliance with paragraph 4. And what paragraph 4 requires is that the mother continue in therapy, that she get an evaluation, and then she continue in therapy until successfully discharged by the therapist. Now, Ms. Gaddis went to Renew. That's the county's therapist. It's I don't know if it's quasi-county or whatnot. It's whether it's got county funding or whatnot. But it's not Jim Bob's online therapy that she signed up for. Online therapy, 1 hour, we'll give you whatever you need, pay us $100 and we'll write whatever you want. It's Grant Renew. It's the mental health counseling for the county. It's where dependency goes. It's where, that's who CPS uses and sends people to. It's not a fly-by-night operation. She went there, she got an evaluation. They were supplied with the parenting plan. Unsure about the CR2A. It doesn't appear that there's anything really materially different in that CR2A. But, there's quotes from the parenting plan about the type of therapy, about involving the exposure to conflict and the implementing boundaries, telling the truth, all that. So she went there, she did that. She did not supply compliance reports. However, the therapy only lasted for less than a month. It was literally evaluation in March, discharge letter in May, and you had to do the initial intake and evaluation in between. She went to, as near as I can tell, 1 or 2 sessions and then was discharged with the letter. And the letter is from the therapist that discharges her. The court's going to find that she met compliance with paragraph 4. I think that's clear. Now, the only thing is, Ms. Zink, all that does is allow the courthouse door to swing open. And it does not allow the removal of 191 restrictions or anything like that. It's limited to just whether there's going to be supervised or unsupervised visitation, and how much, if any, is it going to increase. Now, Dad has raised some issues, and the amount and type of this counseling, I think, is going to be relevant at trial. And it's going to determine, what is going to ultimately occur. But in the meantime, the court is not going to enter any sort of temporary parenting plan. We have a final parenting plan that's in place. The court, unless there's extreme circumstances, the court doesn't deal with entering temporary parenting plans upon a finding of adequate cause. We have a final parenting plan in place. The parties are going to follow that. Ms. Gaddis hasn't shown that that the parties they got back together for the past year and have been living together and dealing with the children on an equal basis. And then they broke up again. And now Dad's wanting to resurrect this old parenting plan that the parties just haven't been following. That's not the case here. There's an existing parenting plan. The parties have to go to mediation. Well, actually, mediation, I guess, has been waived. The court will waive, the parties entered that agreement under the parenting plan. The parties don't have to go to mediation, but there's going to have to be a trial on this unless the parties reach an agreement. And in the meantime, the court's not going to disturb the current parenting plan. But Mr. Schaefer and Mr. Gaddis, Mom's met the requirements. Now, Ms. Zink, whether that's, how much, the amount and quality of that counseling is going to be, a trial issue. So I'll leave it at that. Adequate cause is found for it to move forward under paragraph 7 only. That's all that's moving forward on. If the parties reach an agreement, great. If not, you'll note it up for trial. Mediation is waived. So anything else, any questions from the parties or?
Your Honor, just one to clarify, you said it was met under paragraph 7. I'm assuming you mean 4 and 14. Is that right?
Yes, 4 and 14, paragraph 7 of 14.
Oh, I
is
see.
The one that lays out what can be determined at trial. Adequate cause is found under paragraphs 4 and 14. What will be at trial issue is what's listed in paragraph 7 of paragraph 14.
All right, perfect. Thank you for clarifying, Your Honor. I have no other questions. Thank you.
So, and I think, Ms. Zink, you provided a adequate cause order, correct?
I can't be
Maybe
certain
not.
of that, Your Honor.
No, you guys didn't. You supplied a parenting plan and like I said, I'm not ordering any changes. Ms. Zink, I think you and Mr. Schaefer can probably agree on the form of the order. If you can prepare an order and get it to the court, finding adequate cause for the reasons listed on the record or whatnot, and that trial will move forward. Mediation is waived in this case, it's been waived. So the parties can note it for trial when they're ready. I would, I don't know what discovery the parties are going to want to do. So if there's some dispute about trial setting, I guess you can note it up down the road, but I know there'll have to be a little bit of discovery done or whatnot. So anything else?
Nothing for me, Your Honor. Thank you.
Nothing for me. Thank you, Your Honor.
Okay, I don't need to set a presentation. You guys can just get an order and note up a presentation if there's some dispute.
That's fine, Your Honor. We work well enough together. I think we'll be fine getting it done.
Okay, perfect.
Thank you.
Thank you, Your
Thanks.
Honor.
All right, we got 10:40. We probably need to take the morning break and we'll come back. We got a few cases. We'll see if we can plow through those. We'll be back in 15 minutes at 10:55. We'll see if we can't get through the rest of them. I'll mute everything and we will have to clear the courtroom so the clerk can have a break too.
Yep, I can.
Okay, perfect. Let's call the Schweiger and Padilla matter, 22-3-261-13.
Riger, and I'm
yeah.
here.
Yes, Schweiger.
No
All right.
worries.
All right, this is on for presentation. Ma'am, did you get a copy of the proposed order?
No, I have not got anything from anyone.
Okay, well.
And I've been home all week because I've been sick. I mean, I'm pretty much over it now, but yeah, no.
Okay, Mr. Huberto.
Yeah, I'm not sure what to say. I mean, I think I did it on Friday, so I mean, there's no reason it shouldn't have gotten to her in the mail by then. But it is on for a presentation here, and I think she didn't file anything in response, so I'm not sure if it matters too much. Your Honor is going to sign an order that you believe is appropriate. By the way, I do have to point out I can hear the court, but the cameras have shifted. I can no longer see the court, but I can see the gallery.
Okay, yep. Hold on.
Not that it matters, I guess. It's just a little off-putting from what we were used to.
Let's see. Is that better?
There you go. Yep, there you go. Now things are back to normal.
Yes, when it's supposed to go back there when we turn them off, but sometimes I have to hit an extra button. So, all right, perfect. So, ma'am, did you file? You didn't file a proposed order?
No, I didn't know I needed to, or what to file.
Well, you can. I had just set it over for presentation.
Yeah.
This order does accurately reflect the court's oral ruling. I'm going to sign it. It does indicate the $100 penalty and the attorney's fees. It does have the makeup time for the next 10 every other weekends. It's supervised with a professional supervisor. That's what that's what the mom wanted. I tried to see if there was somebody else that could do it, but.
And I don't know. So I had someone reach out to me that I'm not friends with her on Facebook or anything, but one of my friends that's friends with her had seen that I was needing someone to do visitations, and she reached out to this person that lives in Wenatchee. She's a mom. She's a very honest person. She's actually friends with Adrian.
Ma'am, let me just stop you there. I had tried to do other people. You wanted a professional. This order reflects the court's ruling. It's a professional supervisor. However, as with any order like this, if the parties agree otherwise, so if you and Mr. Padilla can agree to his mom, this lady in Chelan, President Trump, whatever. If you guys agree to someone, then you can do it, but you have to both agree to
Okay.
it. So if you
Okay.
guys arrive at something, great.
Okay.
All right. I've signed the contempt hearing order. We did not, there is no review set. I just expect the parties to comply with the order and we'll see where things shake out at. Hopefully the parties, Mr. Huberto, if there's somebody that is agreeable to your client, then, you know, maybe you'd be able to, you know, the court doesn't care if it's professionally supervised so long as the parties agree.
Understood. Thank you.
All right, thanks. All right, let's take the Bessel matter, 23-3-328-13. Good morning. Mr. Anderson, you're here on behalf of Miss Bessel, correct?
Yes, Your Honor. I would just ask court if we could just put this matter off for just a short period of time. My client was in my office when the court called recess. She went across the street to McDonald's to grab an iced tea and has not yet returned.
Okay. We can do that. We'll set this aside, and not to prejudice Mr. Gilreath for being here. We'll go ahead and take the Fulkerson matter, 24-3-110-13.
James Gilreath on behalf of Craig Fulkerson.
And Mr. Decker.
Yes, Your Honor. I represent Miss Walls. I believe in the caption, it's still Miss Fulkerson, but
yeah,
she's changed her name since then.
Okay. The court has a preliminary issue. This is on for a motion to enforce. Is this really not a motion to clarify? I will ask the parties that and see. Enforcement, if there's something in there that specifically says you shall sign a quitclaim deed affidavit and real estate excise tax affidavit, you know, I get that. But I'll ask the parties, is this really, this case has a tortured history and you guys don't seem to have learned from any of the torture that occurred in the past. So Mr. Gilreath,
I believe it's a bit of both. I think that the reason that both parties are here are because both parties signed up for the Columbia Basin Dispute Resolution Center, and I'm not going to take my full 10 minutes to blast them because there's not enough people in the audience to heed my advice not to go there. But I think it's a bit of both, Your Honor. It's enforcement and clarification.
okay, Mr. Decker, do you agree it's enforcement? I mean, you're basically arguing that to a certain extent that it's not. I mean, the thing is the parties reached a mediated agreement and, you know, obviously it is, they went there twice. It's on multiple things and it's all on one page each of paper. So you obviously aren't going to have every single little detail worked out, because if you guys can be reasonable, then it would just get done. But are the parties wanting to go forward today, or do you want to either, I can kick it over, you guys can see if you can clarify it yourselves, or if you want the court to clarify it, then fine.
I think the court should clarify. I don't think that kicking this any further will be of any benefit to any party in this action.
Okay.
I think that the court's made notice of the 2 pages and that of those 2 pages, nothing has been done. And so that's why we're here today seeking enforcement, but also some form of clarification because the dates are passed.
They don't say anything though. It doesn't say who gets the boat. So, all right, I'll let you guys give me.
But it does say the boat's to be sold. I mean, it says,
yeah,
but.
Doesn't say how, doesn't say who gets it, doesn't say the process. That's what I'm saying. It's a motion to clarify. It also doesn't say, it says the same on the quadro to be started. Doesn't say how to pay, doesn't give any of that stuff, because if people were reasonable, you guys would work that out. But
that's another point I had, Your Honor. It also, the biggest asset in this dissolution is the house. And it doesn't say when the house is to be sold.
Yeah.
And so I think it's in the benefit of both sides to get that resolved today as well. I mean, we're not trying to hide anything or conceal anything. We just want finality to this. And
You haven't really, and I guess my only issue is this, you haven't provided how you want it clarified. Even you, Mr. Like you want the boat sold. You don't even indicate how, so you want the boat. It doesn't say in here, it says the dad is to have the boat. It says Craig agrees to take the boat if insured to Lake Roosevelt to attempt to get the alarm problem resolved. So, but that's it.
To maximize the
That's
sale
it.
as soon as possible.
And that is it. It does not say who gets to use it in the meantime, who gets to have it, how it's to be sold, who gets to decide whether it's sold. The boat will be sold to maximize the sale as soon as possible. Okay, I'll give you $1 for it. Sold immediately, right? I'm facetious about that. I'm just stating there is no mechanism because reasonable people would work together to do this. Ergo, by deductive reasoning, the parties aren't being reasonable. But it's silent, and you each want to just take your own reading of what it should be where it's silent. So again, I'm kind of asking, you guys really haven't laid out any sort of, so on the boat. Okay, I can order things, and if that's what the parties want, I will order it. You guys will sit here and listen and take down the notes, I guess, and it might not be what anyone likes, but there has to be a process. So, and this is what's a little frustrating because I don't know what you haven't even attempted to work out what is missing, the process. So, Mr. Decker?
Yeah, Your Honor, I would,
you understand what
I understand exactly what you're saying. I will say that we didn't supply anything regarding what we'd like it to be clarified as because we prepared as this was a motion to enforce. That's what it was noted for. That's what I thought I was preparing for. If we were to want to do a clarification and have the court order things, I am open to doing so, but I am going to need time to present what I would like the clarification to be. Now, with that said, again, and I understand the court's frustration with the parties not being reasonable. I think counsel and the parties are maybe equally frustrated. I don't understand why we're here in front of the court. This is stuff that really should be taken care of between counsel and I, where the parties can just agree to get these things moving. This has been sitting since September of last year. I don't even know how many times we've been in front of the court on this stuff. If we want to set it over for clarification or strike it and renote for clarification, I won't object to it. I would just like additional time to get my proposals in. With that said, in the interim, I would really suggest, and I would indicate to the court that I'm going to have a conversation with my client about resolving this out of the purview of the court. This has been going on for too long. Okay. I think the issues are pretty clear on where the discrepancies are, the boat sale, the quadro process.
Insurances.
The insurances. This is really something that I believe Mr. Gilreath and I should really be able to work out between the next clarification hearing.
Mr. Gilreath?
I agree, Your Honor. We just renote it for clarification. It is my hope and my client's hope that we can resolve this beforehand.
So
I believe that this is the first time the property issues are before the court, not 4 separate protection orders from both sides. But this is the first time the property's made it before the court.
Okay. So what the court will do is this. I'm going to strike it as a motion to enforce. I'll let counsel, if necessary, renote it as a motion to clarify. If it gets renoted as a motion to clarify, I will need, what has to be clarified is the process. You guys have already agreed this is to happen. It's just none of the detail was laid out. And so if you're unable to reasonably resolve it, then renote it as a motion to clarify, give me your proposed process of what it is, and what's missing. And I don't want to knock the Columbia Basin Dispute Resolution Center. They're not attorneys. I understand that. But the parties went in and, the basic framework of everything is here. It's just the detail. And if the parties get crossways, then the detail matters, because then it's like, well, and it's each of them that's just unfortunate. So motion stricken. Do not renote it as a motion to enforce. The issues that you guys filed on, the insurances and the vehicles and that whole mess, which I didn't quite, that's the only one I really wasn't quite wrapping my mind around, was the GISA credit union account and what's required. But I got the gist of it. I just didn't get quite all the details. The boat was pretty simple. I get that, and the same with the Quadro. So, all right, we'll strike it. You guys renote it if necessary. Hopefully it won't be necessary. Or if it's only necessary as to one thing, then great. It'll be pretty straightforward. So, all right.
All right. Thank you, Your Honor.
Thanks.
Your Honor. Do you want me to stay on for?
Yeah, is Mr. Anderson, are you back? Or is your client back?
Yes, Your Honor. We are both. She is sitting across the desk from me at this time. Thank you for your indulgence.
We'll recall the Bessel 23-3-328-13. I reviewed the materials. According to the parents, neither parent is a fit parent. I don't know if CPS shouldn't maybe just take the kids. With that said, I'll hear from both parties. I don't want a regurgitation of the facts. Tell me why I should do what you want me to do and what specific facts support that. You both claim the other one is the devil incarnate. So go ahead.
Thank you, Your Honor. I guess we're the petitioner in this matter. We'll go first, or once you filed for this matter, I guess.
Yep.
I have spoken with my client. Per the court's ruling 2 weeks ago, last weekend, the children did spend time with the father. It went well. So I guess we have backed off, as Your Honor said, of claiming he is the devil. One of the concerns we have, though, is the current domestic violence charge, as well as the 3 felony drug charges that arose from this incident that gave rise to our moving forward with this matter. So for that reason, we're asking the court to enter a parenting plan that names Ms. Bessel as the primary residential parent, that allows Mr. Bessel to have every other weekend visitation, I believe Friday at 6 to Sunday at 6. Obviously, Father's Day would be with him, and kind of your standard parenting plan, any Monday holidays attached to the weekend. I do apologize. I was looking back over the materials that we filed on our child support worksheets. I don't know what happened. Somewhere along the lines, I mistyped in the father's income and came out with something like $23,000 a month income for him. I didn't realize that's greatly in error. At this time, we would stipulate to the child support worksheet submitted by Mr. Bessel and ask the court to order child support based upon that paid by Mr. Bessel to Ms. Bessel. And our request for spousal maintenance, I'm going to withdraw that at this time. We'll file it at a later date because we did not, I have not filed any financial declarations from Ms. Bessel. And I realize the court needs those in order to make that type of decision. So we are asking the court to either reserve on that, or we'll just withdraw our request for that. And then as to the use of property, Mr. Bessel indicated he would like to have the 2017 Audi Q7, the 2022 Ford F-250, and the 2016 Audi S4 in his possession, and that Ms. Bessel use the 2013 Audi Q7. At this time, Ms. Bessel currently has the 2017 and the 2013 Audi Q7s. We would ask that she continue to be able to use those, and that Mr. Bessel get, right now, at this point, The tabs have expired. The cars are in his name. So we need to have them, if you will, registered so that she or get the tabs so she can legally drive them. Otherwise, they're of no use to anybody. And I believe that's what we're asking for the court to enter an order today.
Okay. Mr. Gilreath?
Yes, Your Honor. I'll try and be brief. I'll address the parenting plan first. Ms. Bezel filed a parenting plan that provides 0 time with my client. There's no part in there where he actually gets an overnighter time with them. We presented a parenting plan that's 50-50. We do allege 191 factors for substance abuse, neglect, and substance abuse and neglect. The parties previously have filed a 50-50 parenting plan.
No, they filed a split custody one that they each had. They filed a joint parenting plan that wasn't signed by the court, but signed by both of them. That says dad got the older child and mom got the younger child during the week, and they swapped weekends so the kids were together with each other on weekends.
So they're splitting their 2 children 50.
Splitting up, yeah.
Right.
They each get.
He
Dad
gets more
had
time under that plan
Yeah.
than this one. And her allegations speak to things that existed a year ago and prior and so long. We propose a public exchange location. I think we're all in agreement there. But the reasons that we've alleged the 191 factors are because of neglect, substance abuse, and suicide attempts, which are corroborated by her mother's reply declaration. She states that she's now off drugs, but she doesn't say how long she's been off drugs. Ms. Bezel admits that she does wake up after lunchtime. That corroborates my client's declaration and his family declaration that children are just out in the yard. The suicidal behavior we put on text messages from the mother to my client, very concerning. But it's our understanding that the property request that we're making is that dad gets to stay in the home because he operates his business out of the home. And if he's operating out of the home, then mom is living with her mother. And so we get our supervised visitation or supervised residential schedule that way, because that seems to be working.
And Mr. Anderson, your client doesn't want the home. She's moved in with her mom. Is that right?
Right. That is correct, Your Honor.
So she's fine with dad having the home. I'd leave it to you guys to work out. I don't know what the criminal no contact order says. If it has that address in there, that would have to be addressed in the criminal court order.
And
if it just says where mom's residing and she's not residing there, then it's a different matter. But I'll leave that to you
Our
guys.
office is on that. It's our understanding, though, if you order something, that is modifiable in district court.
Okay.
That's our understanding there.
Yeah, my understanding, Your Honor, both the district court and the superior court order, says not to be within 1,000 feet of Ms. Bezel's residence, school, such, but it does not list it. But it also does, both of them list that he, for a civil standby order at that address. So it is somewhat interpretable either way.
Okay.
So yeah, but that's something that can be addressed through both the superior court and the district court.
But I believe that the property request is quite simple, because if he can't go home, he can't work.
Yeah,
And if
well,
he
it
can't
sounds
work,
like it's
he
not
can't provide
disputed that
support.
he's going to get the home.
Right.
You'll just have to work, if there's any little fine tuning details,
Okay.
I can order that he get the home in this case, and then you would have to work out anything with the other courts.
And then that goes towards our proposed parenting plan of a 50-50, is that half the time they're with dad, half the time they're with mom, and mom has her mom there helping them. As for the argument on attorney fees, we allege that she's taken about $29,000, and we put on proof that she has now paid her unpaid child support in a separate matter, I think in the amount of $12,000 to $14,000. And they did reply with a check from the mother, but that doesn't prove anything. I could write you a check for $1 million and take a photo of it. That doesn't prove that that money was used for that thing. And then as for the car request, we are requesting the 2017, the Ford, which is his daily driver for work, and then the other Audi as well. And it came up in the reply declaration. The reason we'd like to do that is because she has the Audi Q7, I think it's the 2014, She can transport the kids that way. She could get to work if she gets a job. Getting on a 50/50 will allow her to get a job. And she wants to sell the cars. I think our proposed temporary family law order precludes both parties from selling community
Yeah.
property.
No one's selling anything without agreement of the parties or a court order. So.
But I think that her reply declaration speaks to what she wants these things for. She's just trying to cash out here. She's trying to sell the cars. She's trying to get maintenance. She's trying to get attorney fees. She's trying to, I didn't realize that Mr. Anderson made an error on the worksheets. $23,000 a month. He's not making that plumbing out in Quincy. I guess we aren't arguing worksheets at this point. But we do want the court to take notice of the 191 factors, even though we're proposing a 50/50 schedule.
Okay.
And so that's all I have, Your Honor. I'll reserve for any questions that you may have.
All right. Anything else from you, Mr. Anderson?
Your Honor, I guess I want to say I'm in full support, and I know the court will enter the order that protects the property. Mr. Bessel has already started to sell items. Ms. Bessel has gone out there to retrieve personal items, and all of a sudden there are things missing that were there before. So that's an issue that we'll be obviously addressing later down the line, and more especially towards a final resolution.
Okay. All right. So, Mr. Anderson, you agree to Mr. Gilreath's child support schedule as far as the worksheets. I know he has 50/50, you want custody, but whatever, we're going to use Mr. Gilreath's worksheets. Right?
Yes, correct, Your Honor.
Oh, perfect. All right. So this is kind of a strange case. I was only half joking when I said maybe CPS should take the kids. Both parents have so many flaws. This is a 2023 case that lay dormant for 2 years until this event that happened. I would point out that the parties filed a joint parenting plan that was signed by both of them in 23 that, yeah.
We didn't address the requested restraining order. I think we probably need to address that as well.
So Mr. Anderson didn't supply anything else. I'm assuming you're dropping your request for the restraining order because
there's
you're
no
wanting every other weekend. And
there's no need for restraining order because there's already one in the Superior Court and District Court.
Yep, and we're not including the kids.
That's
so, and it split the custody of the kids. Mom would have the youngest, dad would have the oldest, and they'd swap on weekends. So mom has been a stay-at-home mom. Now dad claims she's a druggie and she sleeps until noon.
Well,
and I've got a bunch of declarations from people, some that are from his relatives that address that. Yes, mom's mom says that the mom was on drugs earlier. By the same token, dad's been arrested for drug dealing and a number of other factors. Both of these parents have all sorts of skeletons in the closet and throwing stones when you live in a glass house. And dad was arrested for the DV. I mean, there's a number of things. Now, dad denies all this.
Because getting arrested,
I understand. He denies
the best interest of the children.
So what is undisputed is mom's been a stay-at-home mom. Mom has issues. Mom's living with her mom. What I'm going to do, I'm going to place the kids with mom. I'm going to give dad ample visitation. So dad's going to have extended weekends from Friday at 3 to Monday at 8. He'll have to deal with getting the kids to school. Okay. I understand dad's been seeing these kids. Dad can have a Wednesday overnight every Wednesday from 3 p.m. to 8 a.m. Thursday. Okay. And starting next summer, we'll do a 50/50 summer schedule. I'm not going to try to deal with it this year. Dad'll have to get the kids to school, order joint decision making. I'm reserving on all the limiting factors. Both parents, I mean, I could find limiting factors on both of them. I'm just going to reserve on them. Child support, we'll use dad's worksheets. I would point out that AGI is not total income per 2619, but for now it'll do. I realize that's all that he put down. He filed his tax statement that just has AGI. AGI is not total income, but
He was
for
precluded
right
from the
now,
house. That was
I understand.
Yeah.
So dad can have the house. Okay, let's order dad can have the house. You have to address any of the no contact orders with the criminal courts. If it just says where mom lives and she's moved and I've given dad the house, then great. If you have to do something more. The mom withdrew the request for maintenance, and I'm going to reserve on any attorney's fees. She asked for attorney's fees. There wasn't really any argument on it. I'm going to reserve on it because I think that kind of just goes in with the withdrawn.
We did state that he front loaded it by her taking the $29,000.
I understand.
So there was argument on it.
Yes, and she claims that that money was turned over to the police. I don't know where it's at. I'm not ordering any attorney's fees. I'm just reserving it. It would have to get dealt with any request for maintenance. Mr. Anderson, if you're going to bring a request for maintenance and attorney's fees, then that would have to come together. I don't want them piecemealed because, if there's anything joint or mutual restraints and the standard restraints, no changing insurances, no disposing of property. For right now, Mr. Anderson, your client can't sell either of the cars.
That's understood, Your Honor.
Okay. Does she want both of them right now? Which one does she want?
2017.
She would like to have the 2017 Audi G7. Or
Okay.
Q7, excuse me.
Okay. Mr. Gilreath, I'm going to give her the 2017. Your client can have the other cars. He can't sell them. Don't sell them.
He's not trying.
I know. I'm not saying anyone is. I'm just saying no one sell.
Well, one party put in declaration that they want to sell them, and they're
I
trying
know.
to sell
And he can't, she can't sell them. No one can sell anything other than he can sell his plumbing stuff for normal course of business. But no selling of houses, no selling of vehicles. So, all right. Did the court, and so there will be child support. It's $1,599 that dad will have to pay. We'll start that in June. Anything else that needs to be addressed?
What's the exchange time on Summers next summer?
Oh, we can just do Fridays.
Okay, Friday at 6?
Yeah.
Okay.
We'll get dads every other extended weekend starting, this would be this week, right? Because he didn't have the kids last week. He had them
Yes,
the
he
week
did, Your
before.
Honor. I believe last week was Memorial Day weekend. He had it for the Memorial Day weekend. He had it
Okay.
through Monday.
That's right.
Mr. Bezel is online, if he could confirm. I see his tile right there.
Yeah, I think I have the order. It said in the order, where's the yellow sheet? Here we go. Continuance, except for Friday 6 p.m. to Monday 6 p.m., May 23rd, 20. Yeah, so he had them last weekend.
Okay.
So he'll get Wednesday, the Wednesday overnight starting next week, and then the every other extended weekend. All right. Anything else, Mr. Anderson? Anything I left out, reserved? You withdrew attorney's fee or withdrew maintenance. I reserved on attorney's fees.
I don't believe.
Yeah.
I believe we're good, Your Honor. I guess we'll set this matter on for 2 weeks for presentation, but with the knowledge that in the intervening week, Mr. Bessel will have his visitation.
Wednesdays and every other extended weekend.
And I believe we can note it for presentment, but I don't think it'll be necessary. If we
You
could
guys
just
will
talk
get the
for a moment
order.
on exchange location. I know that
Sure.
Mr. Bezel lives in Quincy now, and I believe mom is in Moses Lake. They were previously, he was in Rock Island, so if we would like to pick a new
It's
exchange.
Quincy and Moses Lake. The easiest thing is you meet at the police. You want to meet at a public location. Do you want to meet at the police station in Quincy and in Moses Lake? In other words, when dad goes and picks up the kids in Moses, you meet in Moses Police Station. When mom comes and gets the kids in Quincy, you meet at the Quincy Police Station. Does that work for you guys?
It does.
Okay.
I
It splits it.
forgot how to unmute. I'm sorry. I had a question also.
Well, you have an attorney.
Oh, okay. I was just wondering how I should go about getting the car back.
So the attorneys can work that out and make sure that stuff happens.
Yeah, we can
Okay.
work.
So, all right. Anything else from you, Mr. Gilreath?
That's
Next
all
week.
that.
Okay. All right.
Thank you.
Thanks.
Thank you, Your Honor. Oh, I guess,
Yeah.
did the court officially continue 2 weeks for presentation?
Yeah, I'll set it over 2 weeks for presentation. If it's not needed, then
We can strike.
great.
Thank you, Your Honor.
Although I think I might be gone on the 13th because there's a judicial family law conference that I'm signed up for on Thursday and Friday. So,
I don't anticipate having issues with Mr. Gilreath
okay.
getting the orders maybe agreed to and is presented to the court earlier.
All right, perfect.
Thank you, Your Honor.
This is Ms. Black. Mr. Huberto and I are supposed to just get in court's
Yep.
oral ruling.
Let me
Yeah,
get that.
The only
Yep,
thing today.
all right. Let's call the AGIA matter, 25-328-13. All right. This is on for the court's oral ruling, and this was on late last week, and there was a lot of moving parts. So what the court did is I went back through everything, and again, I had missing, or I don't know about missing, neither side really fully developed a parenting plan in materials in their declarations. You know, mom just said that this is what we've been doing and he won't object and it's every other weekend. I'm a stay-at-home mom, blah, blah, blah. And that was about it. And dad said, well, I don't contest that I've only been having every other weekend. That's because mom won't give me more and she's withholding the kids. And he put in a bunch of stuff about his schedule. He didn't, he says that he's involved in the kids' lives, but neither side really, gave a whole lot of detail. But the court looked at everything and his schedule was a little off. And this is and one of the factors the court's to do is to look at the party schedules. So what the court came up with is this. The court's placing the child with the mother. I know the dad wanted a 50-50 plan. The court can't find a basis for a 50-50 plan. But I'm going to give the dad additional time. And what the court is doing, I tried to make it as consistent as possible under his schedule. So under his schedule, dad, on the 4-week schedule, dad has the last 2 weekends of week 3 and week 4 off. He doesn't have the weekends of week 1 and 2 off, and it's not every other weekend. He works 2 weekends in a row. He might have 1 day off of one of those weekends, but he doesn't have the whole weekend off until you get to weeks 3 and 4, and then he has them off back to back. So what I'm going to do is I'm going to give the dad I'm going to give him weeks 3 and 4. On a 4-week rotating schedule, dad will have the weekends at weeks 3 and 4, and he'll have them from Friday after school to Monday at the beginning of school or 9 or 8 p.m. If there's no school. But he gets so he has the whole weekend, Friday to Monday on weeks 3 and 4. On weeks 1 and 2, what I'm going to give dad is this. On week 1, dad has a block of time that's 3 days off. I'm going to give him Tuesday after school at 3 p.m. to Wednesday morning at 8 a.m. or school starting. Dad's going to have to get the kids to school. So on week 1, he'll have a Tuesday overnight, Tuesday after school or 3 p.m. to Wednesday. On week 2, dad doesn't have Tuesdays off, but he's got Mondays off. Week 2, dad's going to have Monday from after school at 3 p.m. to Tuesday morning. And then we're into weeks 3 and 4 where he just has his weekends. I'm not going to give him a midweek overnight during those weeks. He's got the weekends and they're extended weekends. So that gives the dad additional time. It accommodates his schedule. It's as consistent as possible. I realize it's a Tuesday 1 week and a Monday the next, but I couldn't make it work a different way and make certain that dad would be off and have the time off and try to be as consistent as possible. So that's what the court's doing with the school schedule. Any questions from council on that? Week 1, week 2, week 3, week 4. Week 1 and 2 is the overnight midweeks, Tuesday and Monday, and then Friday to Monday on the weekends of weeks 3 and 4. Any questions or clarifications on that, Ms. Black?
Yeah, I guess my question is, during the week, he has 7 days off. He's just been giving one weekend.
Yes. That's, I tried to make it consistent so that dad's seeing the kids every single week. He has an overnight every single week, and that's what the court's doing. So, Mr. Huberto, any clarifications?
No, I think I understand your ruling.
So if you look at his
Trying to
schedule,
look-
week
he
1.
takes the kids to school though on those days, right? That to be clear on as far as the school schedule. Because I
Yes.
think he lives in. It's escaping me. I
He
think
will
that's
have to get the
one-
kids
one
to school. Now,
Okay.
Miss Black, he's going to get the kids to school. On a 50-50 plan that he'd proposed, he'd have to get the kids to school, and he said his mom was available, right?
Absolutely. And if she isn't, because he's not working. So he's
Okay.
that.
Yeah, he's basically off. I think one of the days he might be working days, but I tried to make it where he had the time off, the whole time. So in the summer, I'm going to do a 50-50 schedule in the summer. There's really not a basis to not do a 50-50. The kids aren't in school. The dad has some extended time off. We don't have the school schedule issues of whatnot. The court routinely does 50-50 in the summer for parents if there's no limiting factors and no reason not to. So 50-50 in the summer, standard holiday split, and the kind of little different 4-week rotating schedule. Anything else on the parenting plan the court needs to address?
When does this start?
Now, or, yes, now. The thing is it's going to be dependent upon his schedule. I actually didn't look at that. This is
I think summer
25.
starts here next week, right?
The 4th week. So he would have Friday to Monday, but school is out when 10 days, 2 weeks.
Yeah,
I
actually,
think it's sooner than that.
we're in week 2. Because May 29th, May 30th. Yeah, we're in the second. We're in the start of the second, so.
I think Miss Block and I will be able to figure out the start and what week we're in, so the court doesn't have to waste its time doing it.
It follows that production schedule. I went through that.
Okay.
And so.
Well, I have to look at that again. Mr. Huberto has been, I would never have said that May 30th was week 2 of May. So I'm not clear.
Yeah, good point. But he's on a 4-week schedule, so it might be because it rotates every 4 weeks instead of some months have 5. But Miss Block and I'll figure out in the process. I think summer starting soon. It should be pretty simple for us to start fresh.
He will not. This weekend is the second weekend of his block of time. Starting next weekend, he'll have 2 weekends in a row, but I know we're going into summer, so we're going to get to the 50-50 and, when school's out. So, all right. Anything else on parenting plan that I need to address? Pick up at each other's homes. I didn't really look at that. Joint decision making, all the normal standard stuff. There was really no argument about any of that. Okay, anything else on the parenting plan?
I do have a question that I don't believe is argued, but now with your ruling, it changes things around. So the 50-50 in the summer, I understand that that's pretty standard. However, dad's working. I think he works nights a lot of these times. Are we doing a first refusal just for the summer? I mean,
no, first
stay-at-home
refusal.
mom, where are the kids going to be at night when they're with dad?
So these kids are older. Dad has his mom there. Miss Black, your client's going to need to address that. If your client wants to have mom have some of the time, or if there's a relative that's doing it, I do not want the kids alone at home all night long by themselves.
No, I don't believe that was his plan, Your Honor. And know, if there's going to be right of first refusal, that's going to turn this on its head.
No, but no right of first refusal. That's
Okay.
just a contempt asking to happen. However, Ms. Black, just make sure she knows, or that not she knows, he knows that he's got to address the night work, and as long as it's addressed,
Yep.
perfect.
Part of his
Okay.
proposed parenting plan, and he is on Zoom on here now, and he's listening. So, it's
Okay.
Yeah, he knows.
Okay, perfect. So, I mean, there's no allegations that any of the parents are doing anything untoward or bad. So I'm going to trust that they'll do this, and that the other parent will let me know, I guess, if there's a problem. So,
Sure.
okay.
Thank you.
Anything else on the parenting plan? Can I get to child support?
Please.
Nothing from us.
Perfect. All right. Child support. What I'm going to do, I looked at everything. I am using dad's figures for child support. Okay. Dad's figures for child support. I am not going to, there's no deviation. The child support is about $1,995. I use $2,000 as a round figure. So dad's going to pay $2,000 in child support, or the $1,955 or whatever the amount is that's in Miss Black's worksheets. I know she wanted a deviation on a 50-50 plan. I'm not doing a 50-50 plan, and I'm not going to do a deviation. Even though he might meet the threshold amount, it would just end up adjusting maintenance. So we kind of got to start somewhere. And so dad's worksheets, it's $2,000 rough figure for child support. Dad takes home about $86.50 with dad's worksheets on the lesser amount based on him making less amount with the changes in REC Silicon's production schedule. That's $86.50. With, you take about $2,000 off, you get down to about $6,600, which is what he has available to him. Mom, if you impute mom, she's imputed at $4,000. Mom is working. She's working side jobs and isn't fully employed, and she makes about $2,500 according to her, and $4,000 is what would be imputed to her. What the court's going to do for purposes of determining maintenance, these parties have been married for a long time. They have kids together. Mom's does not have the same earning capacity right now that dad has, and both parties have a duty to support each other. I am going to order $1,000 of maintenance. $1,000 of maintenance takes dad's amount down to about $5,500 or $5,600. If we use mom's net income based on her, if she's actually working, it makes her income be about, $5,100 or $5,200. I know she's not making quite that amount right now, but that gives her an incentive to make it. So $1,000 of maintenance dad will pay to mom. I will allow the parties to revisit the maintenance. I'm not going to set a review date, but they can note a review if they want, either side. After I had November 1st, I don't really see a reason to change that. I'll leave it at November 1st. That's about 5 months out. It gives mom a little bit of a chance to, get her employment set. Mr. Huberdeau, she needs to be looking for work and starting to do, a better job of working. I'm going to leave the $1,000 intact. I'm not ending it in November, but dad can come in if he wants to and attempt to lower it, or mom could come in and attempt to raise it. But, and the only other thing that needs to be addressed is dad needs to provide on that same November 1st date, new pay stubs, updated pay stubs to mom for both year to date for this year and year to date last year, to see if the reduction in hours has continued, so to speak. I'm giving dad the benefit of the lower amount right now, but he's going to have to supply pay stubs on November 1st to mom to show that that is continuing. The same method, year to date this year and year to date last year. So,
Well, Your Honor, if he loses his job before November 1,
oh, yes,
not prevented from coming in before November 1.
no. If
Okay.
if there's any substantial change in circumstances, the parties can come in and do whatever. I'm giving the parties an ability to review the maintenance after November 1st.
Under these circumstances or whatever they change to, because he works at REC. That's not a guarantee that he'll still have his job in November. So
I know. Yeah.
All right.
Yep, I understand as well.
Okay. So do the
Start date,
parties,
Your Honor?
yes, I think that's it. There were no other no one asked for, and the standard mutual restraints don't change insurances and no one sells stuff. I've got the worksheets from Miss Black, but I don't know if you probably need to put in the other stuff and maybe just make it all better. So I'll let you guys do the orders.
Yeah, and perhaps we can put this on for that June 3rd. Oh, if you're going to be gone, that doesn't do us any good. We'll just note it up if we can't come to an agreement.
If you can't come to an agreement,
unless
note
Ms.
it up.
Black, you want to put it out that 3 weeks just in case.
I mean, we could. I just hate having junk on the docket when we don't need it. But I mean, if we need it, I'm assuming that these start dates are June.
Oh,
well, I would assume that it should be May, but maybe we can address that now.
Let's do the start date June. We are at the very end of May.
Yeah,
I'm
but Your
covering
Honor,
the $1,000 of maintenance. So
Your Honor, can I be heard on that before you make that final though, because it wasn't addressed. I mean, we filed this May 8th. Here we are on May 30th. It's not
I
our
understand.
fault that it got continued. Plus, she hasn't received any money. I mean, this is a guy that's made over 10 grand, and I think she got 1,800 in, what was it, February was the last time he paid?
Oh, we can have that argument when it comes time to discuss back amounts owed or something. But I think we start now.
I'm going to start it in June, and I'm going to reserve on any of the back amounts. You guys can.
Okay, so it will be reserved. All right.
Yes, I'll reserve on back amounts. Started in June, so that dad can get stuff. He's got to come up with $1,000, and the 2,000 or almost 2,000 in child support. So
like in 3 days, that stuff's going to do. So
all right. Anything else that needs to be addressed?
Yeah, you didn't rule on the attorney's fees. So I'm going to go on and let me assume that's reserved as well.
Because I basically equalize the payments, I'm denying the attorney's fees right now. I ordered the maintenance. So they're denied right now. I'm not ordering any temporary attorney's fees. They're reserved if you wish to bring, at trial. But yes, I'm not ordering attorney's fees right now. I ordered the $1,000 of maintenance and the child support.
Sorry about my dog.
Okay.
Okay. I think that covers everything.
Okay.
Yep, I do too. Thank you.
All right.
Thank you, Your Honor. And Your Honor, before you, I have, how many matters do you have left on the docket? I see it's about 10 noon.
We got a couple, I think just 2 that aren't guardianships.
Okay, I only had one matter left, Your Honor. I'm not sure if it was actually going to be a hearing because it was with Mr. McGee. I'm not sure if he's on. It was a motion for reconsideration. I didn't get the normal notice saying it was set for hearing or argument or what was going to happen.
Oh, yeah, no, nothing's on. I have to get, it's been busy, so.
Okay,
All
so
right.
I'm not one of your other 2 matters is what you're telling me left.
No, I think the other 2 matters are what? We have Anderson and McGee on, and then we we have the Loomis matter, and what's the other one? Stoyanova. Okay, Loomis and Stoyanova. So, all right.
Okay, thank you.
Yep, those are the 2 that aren't guardianships. All right, let's take the Stoyanova matter, 24-3-298-13. It's on for trial setting. I don't know if anyone's here. I apologize if you still are. They're usually administrative matters. Is anyone present on the Stoyanova matter?
Your Honor, James McGee here.
Okay. Mr. McGee, and then it's Mr. or it's Wen.
Peter's here. And then my client is, I saw his tile a little earlier.
No, but the other side.
I don't know.
Mr. Wen,
It's Ms., Your Honor.
Ms.
Just-
Wen. Okay.
Yeah,
Ms. Wen.
sorry.
Is Ms. Wen present or Ms. Stoyanova? And Mr. McGee,
Yes.
the only thing I have here, they're not here, and I do not have proof of service that you mailed them the note-up slip.
Yeah, Your Honor, I just noticed that too, because Ms. Wynn has she's always appeared. So
okay.
I do see that we sent it on the 13th, but I don't mind sending it over.
Well, I don't have, because I don't have a proof of service in the file.
Yeah, you do need that. And so let me, I can get that filed I can get that filed today. And then, if you wanted,
I can just strike it and it can get re-noted.
That's fine. We'll just start all over again.
Yeah, because I don't have the proof of, I don't want to, it's going to end up, it's the only, the parties have been to mediation, so I understand that. But
we'll just start all over again. That's fine.
See if see if there's a 2-day trial if she's good with that.
Yeah,
All right, matter stricken for no proof of service.
Stricken,
All right.
no proof of service. Okay, thank you.
Perfect.
Bye-bye.
And then the last non-guardianship case is a Loomis matter. This is cause number, where did it go? I can read it off. I got my notes here, but it was a long docket. 22-3-132-13. So, all right. Mr. Loomis, you're here.
Yes.
Okay, and Mr. Anderson, you're here.
Yes, Your Honor. I guess at preliminary, I would like to say I don't think this matter can really be set on today for the motion that is. The parties have never, it's just on for, it's an amending an existing parenting plan. Cause was found, but the parties have never engaged in mediation. We can't come in with a motion to amend an existing parenting plan like this without mediation. The matter was set for mediation once before. Mr. Loomis canceled it because he wanted to wait for the guardian ad litem report. I think the parties need to get into mediation before we can go forward with this motion to amend an existing parenting plan.
Okay, Mr. Loomis, and you've been before the court before on adequate cause has been found. I told you guys get to trial. So you're wanting to modify an existing permanent parenting plan temporarily when adequate cause has been found. And so you guys have got to get to mediation and get to trial.
My intent is not for a temporary, but for a final. And given what
that's not this is a docket. You have to have a trial. Adequate cause was found by Judge Nodell like 2 years ago.
Your Honor, pursuant to all this, you may be aware that I'm actively pursuing this case, unfortunately, in 3 different courts, 2 others in addition to this one. One of them has to do with the appellate court, which has informed me that if we don't have a change in the parenting plan, that they will be managing this case going forward under RAP 9.11.
Well, that's fine. If they want to communicate and handle the case, I have no problem with that. But sir, have you been to mediation?
Not recently, no.
Okay, not since the adequate cause was found.
Correct.
Okay. Under the local rule,
I had brought forth an emergency restraining order, and that was denied.
Judge Gelati denied the restraining order, yeah.
Well, that was, it was not Judge Gelati, it was Melissa Clarkson.
Oh,
I believe,
Judge Clarkson.
just recently.
Okay, I thought.
And that was done without basis, which I didn't understand, and I would like to grasp reasons for that, but that was not given that day. So given the urgency of the matter, at minimum, something to protect these girls, and specifically Rema and Sela. My oldest daughter, Sela, is going to reach majority here in August.
Well, then she's no longer subject to the parenting plan and she can do what she wants.
presumably just not until that date occurs then? Is that correct?
So, sir, like I said, you guys filed a modification. A final parenting plan was entered in February of 2023. You filed a modification action. Adequate cause was found and granted in August of 2023 or September 2023. A GAL was appointed. You've been to court numerous times trying to temporarily modify the parenting plan, and it's been denied in the past. For the same reason, I've told you guys, get to trial. Now we have the GAL that's in the case, and she's filed a report, I think.
Yes,
You know, yeah.
which I would like the court to consider
I've
for the
s-
urgency of the matter, particularly with regard to the restraining order.
And I saw, and Judge Clarkson denied the emergency restraining order. So, ma'am, or sir, you haven't been to mediation. You haven't complied with the local rules for mediation. You've got a trial that can occur. You just need to get to trial.
Well,
So,
it was explained to me by the appellate court that a trial would not be necessary under 9.11 as a function of them managing this case going forward.
Okay,
if we
well then,
receive a denial today.
you can take it to them if they want to enter a temporary parenting plan. I'm not familiar. I mean, they haven't communicated anything with the court on that, but that's fine.
The only question was your position on the motion today, whether it was denied or accepted for review, had to do with my capacity to submit the restraining order as further evidence.
Your Honor, I believe Mr. Loomis is asking questions, number one, the court can't answer. Number two, what is this restraining order? Obviously, whatever it was denied out of hand by Judge Clarkson, and he's basically arguing that it should be brought back up, and we've never been served with anything about that.
Did you serve them with the restraining order materials?
It was an emergency restraining order, which I was not required to do so, but given
No,
its
but I mean
denial,
after the fact.
given its denial, no.
Oh, okay. Then, see, I thought this was on from that when you filed all your, you know, the
was
motion
done-
for the immediate restraining order. Well, I guess you filed that and you filed it together.
They were done about the same time,
Yeah,
yes.
I get that. So, all right. Well, I'm going to deny the motion to modify the final parenting plan temporarily while this action plays out. There's a final parenting plan in place. As near as I can tell, you guys haven't been following it anyway. So, which is
There's a significant item of note that I would like you to review if you have just a moment. Page 40 of the second half of the GAL report had by one of 5 of the domestic violence charges, one of them where there was a conviction, there was a woman by the name of Jeanette in
I
her
understand.
conversations with.
I read the GAL report.
Which spoke of the fact that Tom could kill someone. So those kinds of things and the pattern that it illustrates, bringing us up to present, I hope for the court would illustrate the urgency of this matter.
So, like I said, the immediate restraining order has been denied by numerous different judicial officers. You have a trial, or you have the ability to get a trial, get to mediation, get to trial. I've ruled previously about you have a final parenting plan. You need to follow that. I saw the GAL report. I also know the parties factually really haven't been following it, so I don't know, you know, as far as an immediate harm, the parties are,
Well,
you know, at trial,
yeah,
it'll all come out.
2 of the 3 children are with me, yes. They're in Moses Lake. So it's my son who I'm not being given adequate communication with, that his position is of greater concern, particularly when we see the mental health issues being verified on their mother as well as Tom, who is
sir,
illustrated in the past.
like I said, these are all trial issues. Get to trial. It's been 2 years. Get to trial so it can all be vetted under the crucible of cross-examination and direct testimony and the whole bit. Everyone gets their say and gets to present their materials. So get to trial. We have a final parenting plan in place right now. And I don't have anything from CPS hasn't come and taken the kids. Law enforcement hasn't come and taken the kids. There's a number, I acknowledge the GAL's report, and that's in there, just like your materials are in there and the mothers, everyone gets a chance to say something, but we have a final parenting plan and adequate cause has been found.
There are
that's
two,
it. I'm
two
I've
aspects
ruled-
that we're
no,
not.
Sir,
Okay.
it's,
My-
so, all right, it's not ripe under LCR 7. You have to go to, or not, the local rule for mandatory mediation, LRMM. You have to get to mediation. You haven't been to mediation. We have a final parenting plan. I rarely disturb the final parenting plans temporarily on modifications. And so, all right, thanks.
Thank you, Your Honor.
All right. Then let's call the Jesse James Pankowitz 25-4-100-13. Oh, sorry. All right. Are any of the parties present on the guardianship of Jesse James Pankowitz 25-4-100-13?
Your Honor, Victoria Iverson again. I will be filing notice of appearance in this case.
Okay, you're going to be in the case? So
I will, yes.
Okay, perfect. Then, yeah, I file a notice of appearance, but you're saying in an open record or an open court on the record. We'll take that for now, get that notice of appearance in. So, Miss Iverson, I don't know exactly what to do with this case because I acknowledge under 11-130-320, upon the filing of a petition for an emergency guardianship, the court has to appoint a court visitor. However, that kind of presupposes that the petition for an emergency guardianship is fully and adequately filed and filled out. What I've got basically is half. I mean, the petition doesn't list the wife other than in some of the materials, but in the service of the notice parties, no wife's listed. The father isn't listed. It lists people that your client, for near as I can tell, there's kind of two camps. The mom's, grandma to the kid, mom to the
Right.
to the adult, to the ward, the alleged ward. Her and her camp, she listed all of those people as necessary parties and then left out anyone that didn't agree with her, from what I can tell from the materials. So what do I do with this? Are you going to file an amended petition that kind of remedies all those things and then I can appoint a court visitor? I just don't know about appointing a court visitor if we haven't even given the wife, who's obviously a necessary party, to any action, a notice provision, does that make sense? That's why I kind of put it here. What do I do with this? Plus, I also have no medical records. I mean, I have the medical records, but all they say is he's there. I really don't have anything medically that says, what's going on and what's his capacity and, why he can't. I mean, I understand he took a bunch of, he had a fever and took a bunch of Tylenol and it wrecked his liver. And then things happen from there, awful things that, are unfortunate. But what do I do when I got a grown adult? I got limited medical and not giving notice to dad or to wife. So I'll be quiet now and let you talk. What do I do with this?
Okay, so Your Honor, I have spoken with the petitioner in this matter. She actually came and spent several hours in my office last week. So I did initially have her, actually, I think I typed up most of the paperwork, or she did, I can't remember now actually, but So yeah, we did get it. I know that there has not been service on the wife yet. We were planning on doing that yesterday, but something came up, and we were able to. So we were actually going to see if we could continue this a week to give us a chance to serve the wife and the AIP. I believe the father is also down in Colorado. The reason this was brought forward most recently is because prior to arriving at the Craig Hospital in Colorado, mom had access to all the records, which is what we provided to you last week. She has now, they have now cut her off from all the medical records, so we can't access anything from Craig Hospital in Colorado. So that was one of the reasons why we were trying to get the medical records and get at least an emergency appointment so we could get access to those, so we could get those to the court. So we do
let me
plan
interrupt you
on
for just-
serving all the necessary parties.
Let me interrupt you for just a quick second. I guess I missed that little, I would call salient detail. Dad's not in Washington, or Dad, I'm in the family law mode. The AIP is not in Washington, but is in Colorado.
He is currently in an inpatient rehabilitation facility in Colorado at Craig Hospital.
So
his residence is in Moses Lake.
Yeah, but for emergency okay. I mean, what can the court, this doesn't need to be brought down in Colorado because that's where he's at? I mean, do I have authority over Colorado? You know, I mean,
it's my understanding that this court has still has jurisdiction because his permanent residence is in Moses Lake.
Washington. Okay, fair enough. I just, when he's down there, I mean, it just adds another layer of, medical. Oh man, I'll leave that to you guys. So, okay. So you want it kicked over a week. I can do that. Next week is a bear.
I heard that.
You can get it. I can kick it over a week. Mom didn't, or the petitioner didn't list wife or any, I don't even know the wife's name. She described the wife in the body of the guardianship petition as, well, she won't even let him do anything or give him pain meds or things like that. But when it lists in that appendix A where you're supposed to list all the people, wife isn't listed there. So I don't know her name, and so I don't know if you want to do an amended, at least list of all the necessary parties, notice parties as far as dad and wife and all that. But I'll kick it over a week then to next Friday. Let you guys get all that stuff squared around. And yeah, I can appoint a court visitor once I kind of have a fully filled out, accurate petition. I don't want the court visitor, it's kind of, needs to, I just didn't want to get in the middle of a half done matter.
Your Honor, I think I just got a text from mom, and I think she had a question for the court. I'm not. Miranda, did you have a?
Yes, I actually did. I can tell you that we did not serve the papers last night because Jesse was scheduled to be, he was able to go out on an outing this morning on a pontoon boat, and really did not want to ruin that for him. Considering he has not been able to go anywhere since January.
How is this so I guess that undercuts whether it's an emergency. I mean, if it's,
well,
so ma'am, you have an attorney, so I'll hear from the attorney.
Okay.
Sorry.
I'll set it over a week.
But just
I'm
a week.
just, it's.
I can tell you the reason for the emergency is that there has been talk of removing him from the rehabilitation facility before he is ready. And we don't want that to occur. So we do believe that this is an emergency situation.
Okay. And again, I would need stuff from the doctors that are going to say what, but all right, set over a week. I'll let you guys deal with it. Again, if it's, yeah, but all right, thanks.
Thank you, Your Honor.
And then we'll recall the 2 guardianships that I called first. Guardianship of Alicio Villegas V, 22-4, 240-13. Anyone present on that? Calling it for the second time. Anyone present on the guardianship of Alicio Villegas V? This was passed over this morning when I called it first. No one's answering. The matter is stricken. And then the guardianship of Ashley Gonzalez, 23-4, 112-13, calling for the second time. Is anyone present on the guardianship of Ashley Gonzalez? Called it the second time. Nothing's been filed by anyone. I'm going to strike. We don't normally set reviews. This was set for review. I understand why. It was kind of a contested matter, but no one's filed anything and no one's here. So matter stricken. Parties can renote if they feel they need to in the future. All right, that's all the cases the court has. Anyone have a matter they think was on the docket and wasn't called? Anyone have a case they think was on the docket and wasn't called? No? All right. We'll be in recess. Everyone have a great weekend. We'll be back at 1:30 for the pro se docket. I'll leave the docket up and just mute and turn things off. Cameras. All right, this is the pro se family law docket. If you're here for something besides pro se family law, you're in the wrong courtroom. So if you have a criminal case, you need to go over to courtroom 1. If you're here for a family law matter, you're in the right place. All right. This docket's being conducted via Zoom. That's the county's new video and telephone conferencing system. Courtroom doors open and unlocked. Members of the public can appear in person or on Zoom. Likewise, counsel of record and pro se litigants can appear in person or on Zoom. If you're on Zoom, you need to keep your microphones muted and your cameras off until your case is called. If we have too many people unmuted at once on Zoom, then it can create feedback through the system and doesn't make as clear a record. All right. We will start with some of the ones, and I'm pretty certain the interpreter is next door, right? We don't have the interpreter yet. Nope. Okay.
So I am present, Your Honor, but I can go next door if needed.
Okay. If you want to go next door, I just kind of figured I would, that you'd be next because are there any intakes that you're doing?
I don't believe there's intakes, but I still need to check in next door.
Yeah, if you want to check in, if I get any interpreter matters, I'll just kind of skip it until you come back.
Sounds great, Your Honor.
And just make sure. I always like to wait, because then if we wait 15 minutes, then when we're done, you can go if.
Understood.
So, all right, thanks. All right, let's see. Let's take the Dearborn matter, 25-373-13.
We're appearing via Zoom.
Okay, can you state your name for the record?
Cindy Dearborn.
Michael Dearborn.
Okay, thanks. So both of you are here. Perfect. All right. I see you delivered some papers. Give me a chance to look them over, make sure they're not blank. Been signed. Okay. Got particular times in the parenting plan, child support order, and worksheet. Okay. And then okay, you didn't put an amount in child support?
That I was unsure of what number to use in that, and so I left it blank for now. Just because there
Okay.
was two different numbers.
What two different numbers?
There was the one numbers that were related to like not to exceed 25% of, and then there was the basic child support minimum number. And so I wasn't sure which one I was supposed to use.
Well, it can't exceed, so let's see, the basic support obligation is $156 and the monthly net income. Yeah, so it looks like so it'd be the $270.77 because the basic support, where'd you get the basic support?
I was also unsure. I was using the worksheet the chart in the back of the worksheet.
Okay. So that's a slightly, well, what figure, I mean, this is all agreed. What numbers are you guys wanting to use?
The lower end number would be fine.
The 156?
Yeah,
Okay, divided by 4 because it has to be an undifferentiated amount.
right. Yeah.
156 because there's 4 kids.
Yeah.
So $39 a kid.
Sounds great.
Okay. All right. So since you have kids, I do need to swear you in. So if you'd both raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be truthful under penalty of perjury, the laws of the state of Washington? Ma'am?
Yes.
And sir?
Yes.
Okay. Who'd like to give the jurisdictional testimony?
I will, and I'm not sure what that is. I apologize.
That's okay. It's answering a number of questions just about the divorce papers and information. It's not difficult. Can you state your name for the record?
Cindy Dearborn.
And to whom are you married?
Michael Dearborn.
And you both live in Washington?
Yes.
And you were married on June 10th of 2006 in Arlington?
Correct.
You separated on the 1st of January 2024?
Yes.
Is your marriage irretrievably broken?
Yes.
You don't own any real property that's land or homes?
No.
You and your spouse have already divided all of your personal and community, all of your personal property, both separate and community.
Yes.
Have you divided all of your debts, both separate and community?
Yes.
When taken as a whole, is that division of all your property and all your debts, is that fair and equitable?
I believe so, yes.
Okay. No one requested any spousal maintenance?
No.
No one requested any protection or restraining orders?
No.
You're not now pregnant, ma'am?
No.
You and your spouse have 4 children that were born of the marriage that are still minors and dependent upon the 2 of you for support?
Correct, yes.
And you and your spouse have arrived at a parenting plan?
Yes.
Is this parenting plan in the kid's best interest?
I believe so, yes.
Does this parenting plan allow for both parents to maintain an appropriate parent-child relationship?
Yes.
You and your spouse have arrived at an agreed order of child support?
Yes.
Are the incomes listed in the worksheets accurate?
Yes.
And are either of you on TANF? That's where you're receiving cash payments from the state?
No, neither.
All right. Anyone request a name change?
No.
Okay. Sir, did you listen to your wife's testimony?
Yes, I did.
Are you in agreement with it?
Yes.
Okay. And so, sir, I have 4 documents here: the findings and conclusions and the final divorce order, and then a parenting plan and an order of child support with worksheets. Did you have a chance to review all these documents before you signed them?
I did.
Are you in agreement with them?
Yeah, I am. Yes.
Anyone make any threats or promises to make you sign them?
No.
Do you want to have the court enter them today?
Yes, I do.
Ma'am, same questions. You had a chance to review all 4 of the documents before you signed them?
Yes.
You're in agreement with them?
Yes.
Anyone make any threats or promises to make you sign them?
No.
You want the court to enter them today?
Yes, please.
All right. Do I have the permission from the parties to write in the $39 for each of the 4 kids and $156 total?
Yes, please.
And sir?
Yes.
Okay. All right. I will adopt the party's parenting plan, find it to be in the kids' best interests, and I'll sign it. It does list out the specific times that each parent has. The parents by agreement can, deviate and do whatever they want as long as they're both in agreement. If you're not in agreement, both of you, then you have to follow the parenting plan. I will
sir.
adopt the party's child support order and worksheets. I did make that change on the order of child support indicating the amount. Neither parent's on state assistance, so the state attorney doesn't have to sign off on the documents. If either of you are receiving TANF, the state's attorney will come in and vacate these orders and make you do it again. So,
All right. That won't be a problem.
I'll adopt the parties' findings and conclusions. And I've signed it. And the final divorce order. The parties are now divorced. If you're there, I guess, if you need copies of these documents, you can inquire in the clerk's office about your purchase options. You don't have to have copies, but if you want copies in the future, you can get them from the clerk's office. They will charge you a small fee depending upon how you get them.
Okay.
Okay, anything else?
Nope.
Nope.
Thank you.
All right, thanks.
Thank you.
All right. And we got the Santiago Hernandez and Rivera Lopez matter, 25-3-16-13. Do you need an interpreter, ma'am? No. Does the other side need an interpreter? No. Okay, thanks. Thank you. Give me a second to look these over, make sure they're signed and filled out and not blank and all that kind of good stuff. The paper clip stuck together. There we go. Okay. Oh, you can go, sorry, you can go ahead and go back and be seated. Okay, they're signed, ooh, but they are blank. Okay. Yep, all right, so. So, ma'am, what I will do, these are your copies. So here, go ahead and come up. This is your copies of other documents, petition to invalidate the marriage, which you wouldn't, you'd have to have different documents for. And I'll hand you back your documents. And then you can go back there because it's being recorded, so that way it'll pick it up. Ma'am, the documents are blank. They're not filled out. You just signed them, you and your spouse. So if there's agreement, you guys need to go through every single number and pick one of the pre-printed answers that make sense, or oftentimes if there's one that doesn't fit you, then there's an other provision and you'd mark that and then write out whatever the answer is. Most of the time there's stuff that works and fits. They're kind of prearranged forms. So, but you guys have to go through and fill those all out. I don't know what your agreement is. I can't fill them out for you. And you and him will need to fill those out, and then you will need to reinitial where you signed and the date. Okay. Do you have access to him? Is he around? Is it easy to?
No, he's out of the country.
Okay. So you have to mail him the stuff and then have him initial. But if you can scan it to him and you guys want to go through it on the phone and then mail him whatever you agree to, or mail it down to him and have him call you, I don't know, whatever you want to do, but they will need to be filled out and then reinitialed next to your signatures for, the changes. Okay.
Okay.
And I won't, since he's not in the country, I'll just strike the hearing and you can renote it when you got everything back. Okay, thanks. All right, the Rodriguez and Meja matter, 24-3-477-13. Ermelinda Rodriguez and Rosa Meja. Oh, that's you guys? Okay. Do you guys need an interpreter? Yeah? Okay. Mr. Castillo, can you go ahead and put your credentials on the record?
Yes, of course, Your Honor. For the record, assisting with this afternoon's docket, certified court interpreter in the Spanish language, number 10837, Jose Castillo, with an oath permanently on file with the AOC. Vamos a llamar el caso de Hermelindo Rodríguez en contra de Rosa Mejía, 24-3-477-13.
Okay. Ma'am, can you state your name for the record?
Señora, por favor, diga su nombre para que conste en acta.
Rosa Mejía.
Rosa Mejía.
And sir?
Señor? Hermelindo Rodriguez. Your Honor, the interpreter is having difficulty hearing them since they're not next
Yeah,
to me.
I'll have them go ahead and sit down.
¿Quieren
And
tomar asiento?
that'll help with the microphones. But do you have signed final documents? You want to hand them up?
¿Tienen los documentos finales firmados por ambos para entregar?
Todavía no están firmados porque dijo que iba a esperar hasta ahorita al momento.
They're not signed yet. She said she was going to wait till we were here to sign them.
Okay, well, this is noted up for an agreed entry of documents, so either you guys are in agreement or not.
Okay, la cita de hoy es para que se entreguen documentos firmados y concordados. Si tienen un acuerdo y firman los documentos, se puede proceder, si no, no.
Are you in agreement, ma'am, or not?
Señora, ¿sí está de acuerdo?
Yes.
Okay.
Yes.
Quítame.
Okay. You want to hand them up? Or you haven't signed them either? Okay.
Muy bien. Oh, falta la firma de usted. Muy bien.
All right, give me a second to look them over, make sure that they're filled out and not blank.
Ok, permítame un momento, los voy a repasar, asegurarme de que todo está rellenado y no hay nada en blanco.
You can go back, sir.
Puede regresar a su asiento, señor.
The parties were already before the court and entered a final parenting plan a couple months ago.
Hace un par de meses las partes estuvieron frente al tribunal y entregaron el plan de tutela de final.
All right. So, sir, I have two documents here, findings and conclusions and a final divorce order.
Señor, tengo dos documentos aquí, el fallo de fallos y conclusiones y la orden final de divorcio.
Did you have a chance to review the documents before you signed them?
¿Usted tuvo oportunidad de repasar estos documentos antes de firmarlos?
Ma'am, or who?
Yes.
Yeah, I
Señor.
thought I said sir, but I could have
Sí,
been. Who
señor.
knows?
Sí.
Sir? Okay. Did, so you had a chance to review them before you signed them.
Entonces, sí los repasó muy bien.
Anyone make any threats or promises to make you sign them?
¿Alguien le hizo alguna amenaza o promesa para que usted los firmara? No.
Are you in agreement with the documents?
¿Está de acuerdo con los documentos? Correct, yes.
You want the court to enter them today?
¿Y quiere que el tribunal los acepte el día de hoy? Correct.
Ma'am, you had a chance to review the two documents before you signed them?
Señora, ¿usted tuvo oportunidad de repasar ambos documentos antes de firmarlos?
Sí.
Yes.
You in agreement with the documents?
¿Está de acuerdo con los documentos?
Sí.
Yes.
Anyone make any threats or promises to make you sign them?
¿Alguien le hizo alguna amenaza o promesa para que usted los firmara?
No.
No.
You want the court to enter them today?
¿Y si quiere que el tribunal los acepte el día de hoy?
Sí.
Yes.
All right, I'll sign the findings and conclusions.
Muy bien, voy a firmar el documento de fallos y conclusiones.
I'll sign the final divorce order.
La orden final de divorcio.
Parties are now divorced.
Ya quedan divorciados.
If you brought copies of the documents, you can take them to the clerk's office. They'll conform them for you for free.
Si trajeron copias, pueden llevarlos a la secretaría para que se los sellen gratuitamente.
If you didn't bring copies and you want copies, you can inquire in the clerk's office about your purchase options.
Si no trajeron copias y desean copias, pueden preguntar ahí en cuanto a opciones de compra.
Okay, that's it. Thanks.
Eso es todo. Gracias.
Thank you.
And we have one other one that's at least marked as a Spanish interpreter, so we'll see. Mr. Castillo, this is the 25-3-166-13, Ana Herrera Lemus and Juan Serrano Berrios.
Vamos a llamar el caso de Ana Herrera Lemus en contra de Juan Serrano Berríos, 25-3-166-13.
You guys need an interpreter?
¿Sí necesitan intérprete? Sí.
Okay. Can you state your name, ma'am?
Señora, su nombre, por favor.
Ana María Herrera.
Ana María Herrera.
And sir?
¿Y señor? ¿Su nombre?
José Juan Serrano.
José Juan Serrano.
Okay, you guys can be seated.
Que pueden tomar asiento.
You're here on a temporary motion?
Están aquí en una petición temporal.
Su señoría, con todo
Sí.
respeto, yo estoy aquí porque a mí mi hermana me llamó de Puerto Rico que yo tenía una corte, porque yo tengo la custodia de mi niña.
Okay,
No
yeah.
sabía ni una corte.
So, Your Honor, with all due respect, I'm here because my sister called me from Puerto Rico to tell me I had a court date. Because I have custody of my daughter. I had not been informed I had a court date.
Okay, you put in a response, sir.
Pero usted entregó una respuesta, ¿verdad?
Sí, la semana pasada traje unos papeles.
Yeah, I brought some papers last week.
Okay.
Muy bien.
So, ma'am, you filed a motion for temporary orders, but I have almost no declarations that outline property or that outline what the positions of the people are.
Okay, señora, usted entregó una petición para órdenes temporales, pero casi no tengo declaraciones apoyando o indicando cuál es la posición que se está pidiendo.
Yo aquí tengo unos documentos que le quisiera enseñar al juez.
I have some documents here I'd like to show, Your Honor.
That's not the way this works.
Esto no funciona así.
This isn't a trial where the parties testify
Este no es un juicio donde las personas testifican
orally.
Verbalmente.
This is a hearing where the parties testify in writing.
En este tipo de audiencia, todo el testimonio es por escrito.
You file declarations and that outlines the parties' positions.
Se tiene que entregar declaraciones juramentadas indicando cuál es la posición de cada parte.
I have a couple paragraphs from you, ma'am, and I have absolutely nothing from the father.
Tengo unos cuantos párrafos de usted, señora, y no tengo nada de parte del padre.
I'm assuming you guys aren't in agreement, correct?
Me imagino que ustedes no tienen un acuerdo entre ustedes en este momento, ¿correcto?
No.
No.
Okay. So I can set this matter out for you guys to file your written testimony with the court and give a copy to each other?
¿Puedo darles una extensión o aplazamiento para permitir que ustedes entreguen su testimonio por escrito tanto al tribunal como a la otra parte?
Perdón, yo ya entregué mis hojas.
I already turned in my documents, though.
So, ma'am, you turned in a parenting plan and your motion, and it has
Entregó su plan de tutela y la petición.
and it has a one, maybe two paragraphs, and that's it.
Uno o dos párrafos es todo.
Again, you're not testifying. It's not a trial where you get sworn in and provide oral testimony. You testify in writing.
Esto no es un juicio donde usted le puede hacer un juramento y usted puede testificar verbalmente. Todo tiene que estar por escrito.
Aquí la única cosa fue que él me quitó a mi hija con acusaciones falsas y yo
The
ya
only thing that's in play here is that he took away my daughter with false accusations.
él comentó que yo había abusado a mi hija y no me dejaron acercar a ella. Ya tengo 2 meses que no la miraba hasta ahorita, la estoy viendo aquí en la corte.
I hadn't seen my daughter in 2 months because they would not let me get near her. I just barely saw her now here at court.
Señor juez, ¿podría hablar un momento?
Can I say something, Your Honor?
Yeah, you haven't filed any response.
Okay,
to
usted no
the
entregó una
motion.
respuesta a la petición de
Sí,
ella.
yo no he entregado nada porque esto me agajó a mí de sorpresa. Yo acabé de salir de preso y estuve con mi niña compartiendo una tarde y cual la tuve que llevar a área de emergencia porque la niña estaba sangrando. Y
Hold on, let me
Permítame,
catch up. He's
permítame.
good, but
Yeah. So yes, I mean, this whole thing, caught me by surprise. That's why I haven't turned in a response. What happened was I was spending time with my daughter and I had to take her, because I had just gotten out of jail, and I had to take her to the emergency room because she was bleeding.
Y de ahí mi niña fue la que procedió a hablar con la doctora y todas las declaraciones que dio la sala de emergencia del Hospital Colombia aquí en Ifreira, eso lo dio la doctora al sistema de CPS y ellos fueron los que todo lo que está en ese escrito fue de la niña y la doctora, porque yo no hablé nada.
Permítame. Yeah, and so I didn't say anything. Everything that is written there is what the little girl told the doctor, and the doctor told the CPS. I didn't say anything.
Y pues desde ese día yo tengo la niña y estoy poco a poco echando para adelante, pero conmigo no hay problema para llegar a un acuerdo o algo, pero que por ejemplo yo quisiera tener más anticipación para saber los días de corte, porque ahora mismo estaba trabajando en un cajo y tuve que venirme así todo sucio y mi niña toda sucia para la corte.
Yeah, and I am not against coming to some sort of agreement, but I need more time, or notice for my court dates because I was working on a car when I found out I needed to come to court, and so I came. I was working on a car, so I came all dirty, and my daughter also not cleaned up to come to court.
You live in Quincy, sir?
Señor, ¿usted vive en Quincy?
Ahora mismo sí tengo un estudio que estoy pagando para vivir en Quincy.
Yes, I am paying I'm renting a studio to live in Quincy.
Okay, that was in your response, what you put as your service address.
Sí, no más porque ahí en Quincy es donde usted puso la dirección para que le hicieran el servicio.
Sí, en el 117.
Yeah, they're at 117, yes.
Ma'am, you live in Mattawa?
¿Y usted vive en Mattawa, señora?
Sí.
Yes.
Okay. And is there an open dependency case? Has CPS taken the kids?
CPS se llevó la niña. ¿Hay un caso abierto de dependencia?
El caso de CPS se terminó y supuestamente que viniéramos a hablar con un juez o algo para determinar la custodia, si compartida o qué días o qué días.
The
Pero
CPS case finished, and we were supposed to come to court to talk to a judge to see about custody or sharing custody or that.
Okay, ma'am.
CPS fue notificado el mismo día que él la llevó al hospital y aquí tengo los documentos de lo que él habló, que yo inducí el dedo en la vagina de mi hija y aquí tengo la prueba de que ellos hablaron con la nena y todo lo que él habló fue falso.
Okay. Yeah, the CPS contacted me the same day that he took her to the hospital. He told them that I had been inserting my finger into the little girl's vagina. I have the records here of what he told them, and they talked to the little girl, and that is false.
I just asked if there's an open dependency. Has CPS taken the kids? Have the police placed the kids in protective custody and given them to CPS?
Lo que yo pregunté espere, por favor. Hay un caso de dependencia abierto, o sea, la policía se llevó la niña y la puso con CPS o
no. La policía y el CPS determinaron que la niña se quedara conmigo desde ese día hasta que se viera todo. Y por eso
CPS and the police determined that I should keep the girl until we came before a judge. That's what happened.
Porque la niña tiene miedo a ir con la mamá y con el vato que está la mamá.
Because the girl's afraid to go with her mom and the guy that her mom's with.
Okay, ma'am, is there an open CPS dependency case?
¿Hay un caso de dependencia abierto con CPS en este momento, señora?
No, CPS cerró el caso porque miró que todo estaba bien, revisaron mi casa, llevaron a la nena, hablaron con ella y aquí tengo los papeles donde CPS está diciendo que yo soy inocente de todo lo que Juan dijo de mí.
No, I have the documents here from CPS that says I'm innocent of everything that Juan accused me of. They came and they talked to me and they talked to the little girl. They went through my house and found everything to be false. I have it right here.
Con todo el respeto, su señoría, yo quisiera ver dónde están los papeles donde dicen que yo hablé o una grabación, porque yo en ningún momento yo hablé con CPS, con el único que hablé fue con el sargento y el policía que estaba de Freira.
Yeah, I never talked to CPS. I'd love to see the report of what I supposedly said to CPS or a recording, because I only ever talked to the sergeant here with the Ephrata Police Department.
Okay. CPS did not come and physically remove the children from your custody and give them to somebody else. Yes or no, sir?
No,
no yes or no, sir?
Sí, no. Solo sí o no, señor. Sí, vino CPS y quitó a la niña y los puso con alguien más, ¿sí o no?
No, me la dio a mí. Estaba
They
conmigo.
gave him to me. Give her to me.
Ma'am, CPS hasn't come and taken the children and given them to somebody else with a court order.
El CPS no ha venido con una orden de un juez a quitar a la niña y ponerla con alguien más, ¿sí o no?
No.
No.
Okay. Sir, CPS did they come with a court order and the police and take the kids physically from you and give them to somebody else?
No.
No.
All right. What the court's going to do is this.
Lo que va a hacer el tribunal es esto.
I have almost no information in the court file in order
Tengo
to
muy
make
poca
an informed
información
decision.
En el expediente como para tomar una decisión.
I'm going to set this matter over 3 weeks.
Voy a
to
poner otra cita en 3 semanas.
What is that? The 20th of June.
El 20 de junio.
The parties are directed to file, you're gonna have to file your testimony in writing with the court and make sure the other side has a copy of what you filed with the court.
Necesitan entregar todo su testimonio por escrito al tribunal y asegurarse de que la otra parte recibe una copia de esa declaración.
It has to be filed under penalty of perjury or
Tiene
it
que
can't
ser
be considered.
firmado bajo pena de perjurio o no lo puedo considerar.
In the meantime,
Por mientras,
I will enter an interim custody order so that the child's not treated like a ping pong.
voy a dictar una orden temporal o interino para que la niña no la estén usando como una ficha.
Do you work, sir?
Señor, ¿usted trabaja?
I'm well for myself. And I got he got your own room, he got everything, and he's stay for me. Every time he's next to me.
You're mixing Spanish and English.
Oh, dile que tengo sitio estable para ella y que tiene su propio cuarto y todo el tiempo, si estoy yo, está ella, no está sola.
Yeah,
O mi amiga la está cuidando o algo, haciéndole de comer o algo.
Okay, I have a stable place for her. She has her own room. If she's home, I'm with her, or a girlfriend of mine, is there to cook for her or take care of her.
Okay, so your flexible work schedule, that's all I asked.
Okay, sí, entonces, es flexible su horario de trabajo.
Sí, pues trabajo en la parte atrás de la casa.
Yeah, I work out the back of my house.
Ma'am, what's your work schedule?
Señora, ¿su horario de trabajo?
Yo entro a trabajar a las 6 de la mañana y salgo a las 12 del mediodía, pero mi niña tiene guardería. Está mejor.
Yeah, I go into work at 6 in the morning and I get out at noon, but my daughter goes to a daycare, so she's better with me.
So, regardless of the work schedule, you can make arrangements when the child's with you, ma'am?
Sin importar lo que sea el horario de trabajo, usted puede hacer arreglos para la niña cuando la niña está con usted, ¿verdad?
Sí.
Yes.
Regardless of your work schedule, sir, you can make arrangements for the child when she's with you.
Y señor, sin importar su horario de trabajo, cuando la niña está contigo, usted puede hacer arreglos para quien la cuiden, ¿correcto?
No, yo hago los arreglos para, si no puedo cuidarla, pues dejo lo del trabajo, pero
Yeah, if I'll skip work if I need to take care of her.
Pero tengo una preocupación, señor juez.
But I do have a worry, Your Honor.
Yo estuve, como le dije al principio, preso y mi niña estaba desde viernes, sábado y domingo sola hasta los lunes porque la mamá se iba de pajanda y de party, por eso yo quiero estar más pendiente a mi hija. Y tengo suficiente
my
vivencia.
worry, because like I said, I just got out of I just got out of jail not too long ago, and my daughter was left alone Friday, Saturday, Sunday, sometimes till Monday, because the mom was out partying and having a good time.
Okay, none of that's before the court.
Okay,
Nothing's filed in the court file. Okay?
Nada de eso está en el expediente, así que el tribunal no puede considerar nada de eso.
What the court's going to do until the next court order.
Mientras se ordena la siguiente orden del tribunal, lo que se va a ordenar es esto.
The parties will exchange the child every 3 days.
Cada 3 días van a intercambiar a la niña.
At 6 o'clock at night.
6 de la tarde.
The picking up parent will pick up the child from the other parent.
El padre que está recogiendo tiene que ir a donde está la niña.
Is the child here today?
¿Está aquí la niña hoy?
Okay.
My daughter.
Okay. So what the court will do
Lo que va a
is
ordenar el tribunal es,
the mom can take the child today.
la mamá puede
She
llevarse a
hasn't
la
seen
niña
him
de
for a
aquí
while.
porque no la ha visto.
In 3 days,
En
the
3
dad
días,
will go pick up the child from the mom
el papá va a ir a
at 6
recoger a la
o'clock at
niña
night.
a las 6 de la tarde.
And then 3 days later, the
Y
mom
3
will
días
go pick up the
después,
child from the dad at 6 o'clock at night.
la mamá va a ir a recoger a la niña a las 6 de la tarde.
We'll have a hearing in 3 weeks to determine what's going to be this is not a workable
today-
permanent
O
plan.
sea, esto no es un plan permanente, pero en 3 semanas se va a determinar cuál va a ser el plan permanente.
If CPS or the police wish to place the child in protective custody, they are free to do so.
Si CPS o la policía quiere poner bajo protección a la niña, ellos pueden hacerlo si desean.
The police can put the child in protective custody if they think the child's in danger, and CPS can seek a court order to have the child removed and placed into foster care if they so think it's necessary.
Si CPS siente que es necesario, ellos pueden pedir una orden de un juez para poner a la niña en cuidado temporal, y si la policía siente que corre peligro, ellos pueden ponerla bajo algún tipo de custodia preventiva.
Pero la cuida. No te vayas para el tiki.
Do you know where each other lives?
¿Sí saben dónde viven?
So today,
Do
Espere.
you know where each other lives,
¿Saben
sir?
dónde viven la otra persona? Señor?
sí,
You know where
Yes.
mom lives?
sí.
Yes.
Mom, you know where dad lives?
¿Tú sabes dónde vive el papá?
Sí, pero él tiene una orden, tenemos una orden, él no se puede acercar, ¿cómo le voy a hacer? ¿Así puedo ir por mi
Yes,
niña?
but there's a protection order. He can't come near me. What do we do about that?
Okay. So you will meet at the police stations and the respective towns
Bueno,
at 6
entonces,
o'clock to
a las 6
exchange
de
the
la
child.
tarde en la estación de policía en el pueblo donde esté la niña.
Hoy es viernes, no te vayas a ir para el tiki.
Yeah. Hopefully you don't go to the bar on Friday.
Disculpe,
Okay.
I'm sorry.
él no me tiene que
Oh,
estar
no.
hablando.
He shouldn't be talking to me.
Unless I talk to either of you, don't say another word.
Okay,
Okay.
ya no hablen al menos que yo les pregunte algo.
All right, here's what the court's ordering.
Okay, esto es lo que está escrito en la orden del juez.
Until further order of the court, the party
Hasta-
shall,
Oh, go ahead, Your Honor.
the party shall alternate care of the child every 3 days.
Hasta la siguiente, hasta que se emita otra orden de parte de un juez, los partes deben intercambiar a la niña cada 3 días.
The mother shall have the child now, ending on Monday, June 2nd, 2025 at 6 p.m.
La madre se lleva a la niña desde ahorita hasta el lunes 2 de junio a las 6 de la tarde.
The father will then have the child until 6 p.m. on Thursday, June 5th, 2025.
Y el padre la tendría hasta el jueves día 5 de junio a las 6 p.m.
This repeats every 3 days.
Esto repite cada 3 días.
The party shall exchange the child at the police stations in Quincy and Mattawa, Washington.
El intercambio de la niña de un padre a otro debe ocurrir en la estación de policía en Quincy o en Mattawa.
The picking up parent shall travel to the other parent's police station.
El padre que esté recogiendo tiene que ir a la estación de policía en el pueblo del otro padre.
Any questions, ma'am?
Señora, ¿alguna pregunta sobre eso?
No.
No.
Sir?
Señor?
No.
No.
Okay, this matter is continued 3 weeks to June 20th
Esto se va a aplazar 3 semanas hasta el 20 de junio
at 1:30.
a la 1:30.
The parties need to get their materials in front of the court.
Necesitan entregar por escrito los materiales que quieren que el tribunal considere.
You will testify in writing, and it has to be in the court file and then given to each other.
Todo el testimonio va a ser por escrito. Tienen que entregar una copia al tribunal y una copia a la otra persona.
You've already filed your proposed parenting plans, but I have no testimony from you on what the facts are on why I should do what you want me to do.
Ya entregaron cada uno el plan que proponen, pero no tengo suficiente información de cuáles son los hechos y por qué quieren que yo ordene lo que ustedes están pidiendo.
All right, that is it.
Eso va a ser todo.
The child will go with mom for today,
La niña hoy se va a ir con la mamá,
back to dad on Monday.
con el papá el lunes.
Every 3 days, repeat
Cada
until
3 días
further
se
order of the
repite
court.
hasta que se llegue a otra orden del tribunal.
Honorable,
Your Honor,
hoy es viernes y pues
today's Friday.
su mamá tiene trabajo viernes, sábado y domingo en el tiki, que yo no quiero que mi hija esté sola hoy, porque voy a mandar una persona a vigilar en el tiki a ver si ella está ahí.
Can I say, okay, so the mom works the next 3 days at the bar, at the Tiki's bar. Can I send someone to go make sure my daughter's not alone?
The parties need to provide appropriately for their child.
Los padres están responsables de proveer lo necesario para sus hijos.
If either parent thinks the child's in danger, they can contact CPS or law enforcement.
Si uno de los padres siente que la niña está en peligro, pueden contactar a la policía o al CPS.
But unless there is another court order or the police take the child into protective custody, the parties must follow this interim order.
Pero al menos que haya otra orden de otro juez o la policía pone en custodia protectora a la niña, se tiene que seguir lo que se ordenó.
Sí, porque mi niña le tiene miedo al vato que está con ella y a ella.
My daughter's afraid of her and the
El
guy
tipo le
she's with.
daba a mi niña y a la otra niña.
Because he was doing things to her and the other kid.
Sir, the police and CPS, if they step in and do something great, you can't take self-help.
Okay, si la policía o el CPS hacen algo excelente, usted no puede tomar su propia acción en cuanto a eso. Okay.
I have nothing in the court file. Get whatever you want the court to consider in the court file. I can't consider just statements from the parties. This is not a trial.
Esto no es un juicio, así que no puedo considerar lo que me estén diciendo aquí. Si entreguen sus declaraciones y cualquier cosa que ustedes quieren que el juez considere para tomar la decisión.
Either party can seek the advice of legal counsel and attorney if they feel that they need so.
Si sienten que necesitan hacerlo, cualquiera de los dos puede hablar con, ambos pueden hablar con abogados.
If there's an active restraining order,
Y si hay una orden de restricción vigente,
then ma'am, why don't you take the child and leave first, and sir, we'll have you wait in the courtroom for about 2 minutes so that nobody gets arrested.
no queremos que nadie sea arrestado
In the parking lot.
aquí afuera, así que
No sería,
si ella se lleva a la niña y usted, señor, se espera aquí unos 2 minutos antes de salir.
no sería mejor al revés, honorable juez.
Could we do it the other way around, Your Honor?
Who's the restraining order? Who's the restrained party?
¿Quién es la persona que tiene las restricciones?
Ella.
You are?
She does.
No, ella.
Her.
Oh, la restraining order me la pusieron a mí.
No, yeah, no, the restraining order is on me. Yes.
On you. Then she leaves first and you wait here.
Entonces usted espere y que ella se vaya primero.
Un beso, que te va.
So
¿Y el teléfono, mamá?
she let him say bye to the child. That's fine.
Deja que se despida, está bien.
But you need to do that.
Pero pasen atrás para hacer eso, por favor.
Thank you.
Yeah, bye. So you stay here, sir.
Okay.
And then ma'am, you leave with the,
Y señor, usted se puede ir
so you need to take the child and go.
con la niña.
All right. Mr. Castillo, that's all the ones that I show as interpreter matters. If you could make an interpreter announcement, we'll see if anybody else needs one.
Your Honor, I believe I have one case that the other party does require an interpreter. That was
okay.
the Salinas versus Cabrera matter.
Okay, yep.
Okay. Vamos a llamar el caso de Salinas en contra de Calderón Cabrera.
All right. This is, I should need to call the cause number. 24-3-232-13, the Salinas and Cabrera matter.
Este es el caso 24-3-232-13, Salinas en contra de Calderón Cabrera.
Mr. Anderson, you represent the mother Gladys Salinas.
That is correct.
Señor Anderson, usted está representando a Gladys Salinas. Correcto, su señoría.
Okay, is Rafael Calderon Cabrera present? Rafael Calderon Cabrera.
¿Está presente Rafael Calderón Cabrera? Si está presente, por favor, identifíquese.
*6 to unmute on the phone, unmute button on the Opera computer.
Estrella 6 si está por teléfono o el icono del micrófono si está por la aplicación Zoom.
Mr. Anderson, did you expect him to appear?
I wasn't sure. We did have him personally served because we didn't have an address to mail to him, but we did find out where he was working, had him personally served at work. I believe that proof of service from the sheriff's is in the file. As you're aware, that we're just asking the two cases that the parties are involved with be consolidated into one case.
So, all right. Sir, you can go. Thanks. All right. Mr. Anderson, the one thing, I don't have the motion filed nor the declaration. I have, this was like the notice slip was filed by your client when she was pro se. Then you put in a notice of appearance. And
I believe the motion was filed, I can't remember exactly, it was filed some time ago. And I did print up a copy of her original motion to consolidate.
So let me stop you there. There's the issue. And I know you weren't in the case yet. So what happened is this, procedurally, your client was unrepresented and Mr. Calderon Cabrera was represented by Mr. McGee.
Yep.
And There were motions that were brought for temporary orders. There were motions that were brought to consolidate the cases, and there were motions to dismiss Mr. McGee for a conflict of interest. The court dealt with the conflict of interest case first, because that's what they have to deal with. That got dealt with, and Mr. McGee was removed from the case. That then went up on revision, and Mr. McGee, as you know, became ill, and the case was continued a number of times due to the illness. And we also continued all of the other cases out past the date of the revision, trying to determine whether Mr. McGee would be in the case ultimately or not. At the end of the day, the revision was denied, and Mr. McGee was removed from the case. Now, that final order hasn't been entered. It's actually due to be entered in a couple weeks. But the parties were before the court on that same day, and that was in April, and the court basically ruled and said, I am striking everything. I said the parties will need to renote and reserve any and all documents because we were so far afield on what dates and where and when. Nobody had notice of when stuff was heard and what was actually what had been continued and not continued. So I guess that's the issue. So I don't have the actual declaration and support from, because you kind of note that there's a declaration that was served.
Yeah, and
I don't have that. I don't know if it's filed in the other case file, but it's not filed in this one. And if you didn't refile the motion, you're going to need to refile the motion and serve him.
As Your Honor is explaining how things went, I knew that there were kind of back and forth as far as the motion to remove Mr. McGee from the case. And I went back and looked at the file and saw where there was it wasn't titled a motion, but in essence, it was a motion to consolidate. That's what we served upon Mr. Cabrera. But in any respect, I will file a new motion with an attached declaration, and I'll renote it up.
Okay, yeah, and everything, because I saw that, I mean, you indicated there's a declaration. I don't even have the declaration in the file, unless it was one way earlier, but.
It was way earlier.
Okay.
Started.
Yeah, and I know this case is kind of just the way it went, so, no, I will, since he's not, if he was here, I wouldn't mind doing it, but he's not here. I don't show that he was served. I show he was served with a note-up slip, but I'm not sure, what all he actually has notice of. So I will strike the hearing without prejudice. You can just renote it. If you guys end up reaching agreement, then you can hand up an agreed order to consolidate the cases. All right. Anything else, Mr. Anderson?
Oh, that's the last matter I had on for this afternoon. Have a good weekend.
Okay. Thanks. You too. All right. We've got the Bickle matter, 25-3-4-13. Oh, and yeah, we'll take this one. And then Mr. Castillo, you're still there?
Yes, Your Honor.
Yeah, so I'll take this Bickle matter and then we'll announce and
No
see
worries.
if anyone else needs an interpreter. We got kind of sidetracked there, so.
No worries.
All right, sir.
I don't think mine's gonna take long, Your Honor. I don't have any paperwork to give you right now. My apologies. I went over and talked to them. They gave me the right paperwork. I kind of hung out just to be.
Sure. No, I appreciate that. Is Jessica Bickle present? We'll just announce. Is Jessica Bickle present? Star 6 to unmute on the phone, unmute button on the app or computer. Jessica Bickle. Okay. And so, sir, yeah, it's on for default. I can tell you I reviewed the file for default. Paragraph 7 is deficient. You haven't shown compliance. If you look at your motion for default, paragraph 7 is the active duty military. You just left it blank. Okay. You have to show compliance with that. You can't just say she's not, you didn't even say she's not in the military. You just left it blank. There's various ways, if you look at the motion, to show compliance. So just pick one of those ways and then show that. And yes, if you've got the documents, the final documents that'll be needed, has it been more than 90 days since the case was filed?
Yes, sir.
Okay, so in order to get default, you will need to remedy the deficiency of paragraph 7, and then have your final documents. With a default, they cannot materially differ from what you filed in your initial petition.
I'm basically just filling it out the same way.
The same way. It materially differ. So there'll be different dates. It'll say final instead of temporary or proposed. But what you can't do on a default, if I were to sue you for a penny and you say, I don't care, and you just don't respond, I can't come into court and say, now I wanted $1 million. Find you in default and get $1 million. If your spouse was fine with what she was served with those documents as they were proposed, then she may not have responded because she didn't care. And so you can't materially alter your requests. Final to from proposed to final is not materially altering. Dates will be different, obviously. You just can't say, hey, my parenting plan, filed says she gets every other weekend and now I want her to have nothing.
Right.
I don't know what you filed. I didn't look. You just can't be different.
Okay.
Okay?
And then do I file another motion for default and then make sure I come back with all this?
No, your motion for default is filed. You can either show compliance with paragraph 7 or file a whole new motion showing compliance with paragraph 7.
Okay.
And then note it up and bring in your documents. If you bring copies, the clerk will conform your copies for free. If you don't bring copies, they'll charge you. So
Right.
if you want to bring copies and for your final documents.
And so I just give that to the clerk's office and I don't have to do
To
anything
note,
else?
no, you have to show back up on the hearing.
Gotcha.
You heard me go through with the other people and some of that stuff. So, yep. All right.
How do I set up another hearing?
Oh, you file another note-up slip like you did for today.
Thank you.
Thanks. All right, Mr. Castillo, let's see if anybody else needs a Spanish interpreter. Anyone else need a Spanish interpreter? *6 to unmute on the phone, unmute button on the app or computer, on Zoom, all that good stuff.
¿Hay alguien más que necesita la ayuda de un intérprete en español? Por favor, indícalo en este momento. Estrella 6 si está por teléfono, enciende el micrófono o el icono del micrófono si está por la aplicación Zoom. Cualquier persona que necesite la ayuda de un intérprete en español, por favor, indícalo en este momento.
Anyone need a Spanish interpreter?
¿Nadie presente necesita un intérprete en español?
No one's raising their hand in court. I didn't hear anyone on Zoom. Did you, Mr. Castillo?
No vi que nadie indicara que sí. I did not hear, Your Honor.
Okay, thanks. It's 2:30. We're an hour into the docket, so if they show up at this point in time, we'll just continue it.
Thank you, Your Honor. Have a good day.
Thank you, Mr. Castillo. You have a good weekend. All right. Next one we have is the Saunders matter, 24-3-287-13. Brian and Brianna Saunders. Do you guys have final documents? Oh, perfect. Thank you. All right. You can go back there and have a seat. Give me a second to look everything over and kind of make sure it's not blank. You probably wouldn't have handed them up if they were blank, right? Hopefully not, yeah. Sometimes I have people come up after that's happened a few times and they kind of, Your Honor, we need to continue this.
Yeah.
Which is fine. So everything's looking good. You got boxes checked, not blank. You signed the documents. I don't look it over to make sure it's all, I don't know what your situation is, whether it's correct. There's a couple things I have to look at. You can't put as agreed for visitation time, and you don't. You have specific days and times. That's perfect. And on child support, you can't leave it blank. Do you have the amounts filled in? Okay. Yep. All right. Everything appears to mostly be in order. All right. So since you do have children in a parenting plan, I have to do jurisdictional testimony. So I'll swear you both in. If you'd raise your right hand, do you solemnly swear or affirm the testimony you're about to give will be truthful under penalty of perjury of the laws of the state of Washington? Sir?
I do.
And ma'am?
I do.
Okay. Who'd like to give the jurisdictional testimony?
I will.
You will? All right. So, ma'am, can you state your name for the record?
Brianna Saunders,
And to whom are you married?
Brian Saunders.
You both live in Washington?
Yes,
And you were married on July 20th, 2013 in Wenatchee?
correct,
You separated in February of 2024?
correct.
Is your marriage irretrievably broken?
Yes,
You don't own any real property that's land or homes?
no,
Have you and your spouse already divided all of your personal property, be it separate or community?
yes,
You and your spouse already divided all of your debts, separate and community?
yes,
When taken as a whole, is that division of all your property and debts fair and equitable?
yes,
Anyone request any spousal maintenance?
no,
Anyone request any protection or restraining orders?
no,
You're not now pregnant, ma'am?
no,
You have one child who was born of the marriage who is still minor and dependent upon you and your spouse for support?
correct,
You and your spouse have arrived at a parenting plan by agreement?
yes,
Is this parenting plan in the kid's best interest?
yes,
Does this parenting plan allow both parents to maintain an appropriate parent-child relationship?
yes,
And so basically an extended every other weekend plus a bunch of midweek times?
correct.
Okay. Anyone request any name change?
No,
And you and your spouse have submitted child support worksheets?
in addition to the ones that.
Yeah, you submitted child support worksheets in order child support. Are the incomes listed in the child support worksheets accurate?
Yes.
And ma'am, you're not now receiving TANF cash payments from the state?
No,
And sir, you're not receiving TANF cash payments from the state? Okay, I wouldn't think so with the income, so. But I have to ask because the state's attorney will come in and remove, overturn everything if you are. All right. And I asked, no one requested a name change?
correct,
All right. Sir, did you listen to your wife's testimony? Are you in agreement with it? Okay. So I have a findings and conclusions, a final divorce order, a parenting plan, and a child support order with worksheets. At the end of each of these documents, you guys signed them. So, sir, did you have a chance to review all these documents before you signed them?
Yes.
Are you in agreement with them?
Yes.
Anyone make any threats or promises to make you sign them?
No.
You want the court to enter them today?
Yes.
Ma'am, same questions. You had a chance to review them before you signed them?
yes,
And you're in agreement with them?
yes,
Anyone make any threats or promises to make you sign them?
no,
You want the court to enter them today?
yes, please.
Okay. I will adopt the parties' parenting plan, find it to be in the kid's best interest, and sign the same. I'll adopt the parties' findings and conclusions and sign the same. I'll sign the child support order and worksheets. I should check, I didn't look. Did you have a starting date in there?
For
Oh, April?
Oh, yes.
Okay, so you're starting it in April?
Officially.
to go away from the state and just pay her directly, is that what you're talking about?
Yeah, it's direct pay,
Yep.
and so it's starting in April?
No,
Meaning-
I'm still paying through the state right now, so I don't know when that starts. I'm
So-
confused.
Well, you started this in April. So is he behind? Is
No, he's current.
current?
Yeah.
Do you want to start this where you start doing the direct pay in June or July?
Yeah.
The only problem is if we go back, what's going to happen is they're going to come take money from you and then give it back to him. And then you're going to have to pay her it back because it went through, because you're backdating this to start. So do you want to do July?
That's perfect.
Okay, it's not really changing the amount or whatever the amount is. You guys are fine with it, whatever the old order
Yes.
Yeah.
said? Okay. So do I have your permission to change it from April of 2025 to July?
Yes,
Okay, that'll give them time to get the July payment in, stop any withholding, and then you've set up direct pay between the two of you.
Okay,
Okay.
perfect.
All right. So I didn't look at that. So sign the final child support order and worksheets and the final divorce order. You are now divorced. Did you bring copies of these documents?
I did not.
Okay. You heard me
Yes.
say, so you can go get your copies and if you want them.
Okay.
You don't have to get them. It's up to you.
Okay.
But if you want them, you can get them whenever from the court. Next year, 10 years from now,
Okay.
today. So, all right. That's it.
Okay.
You're divorced.
Thank
Thanks.
you.
All right. This is 22-3, 159-13, the Medina and Villegas matter. Oh. Hello. Can you state your name for the record?
Deja Medina.
Okay. And is Alicio Villegas the fourth present? Alicio Villegas the fourth?
He got served, but he's in jail.
Yeah. So, ma'am, there's a couple things. I have no service of the initial summons and petition. So if you look at that's just one of the issues. When you initially filed for the modification, you sent it to the sheriff's office and they filed a return of non-service. And what you sent them and what they filed the return of non-service on, I should have marked it. Where is it? Here it is. It says it was returned unserved, and it's the summons and petition, the motion for adequate cause, and notice of hearing. On the 14th of March, it was sent to them, and it was returned, and they returned it to you unserved. They never got him served with that. Now, they did, you then set a motion for adequate cause and a note-up slip, another note-up slip, and they did serve that. It says, the Sheriff Joseph Crete, do hereby certify that I received the notice of hearing and motion for adequate cause decision on the 6th of May, and that I served the same on Alicio Villegas. So he was served with a note-up slip for today and a motion for adequate cause, but he was never served with the underlying summons and petition. Unless you can, if I missed it in the court file, March 21st, I got a sheriff's return of service that shows it was unserved. If you have a different return of service that shows he was served with the underlying summons and petition, then I'll consider that. But otherwise, I don't have jurisdiction because you haven't served the initial summons and petition on that starts the case. Also, you have a guardianship case that was on this morning you didn't appear at. That was a termination. Huh?
They told me it was at 1.
Oh, it was this morning at 9, but that's, at least it was on the docket at 9, which we have to deal with as well. But as far as this case goes, do you have proof of service that you served him with a summons and petition?
No, I mean, I called the sheriff's office to see if he had gotten served with the papers, and they said yeah. But and that
He
they
did
sent
get
it to me.
served with the secondary papers, but I don't have jurisdiction if he's not served with the underlying summons and petition that starts the case.
So I served him with the petition to terminate. Oh wait, no, not that one. Sorry.
It was March 21st,
So-
sheriff's return of service says it was unserved for those initial documents.
I served him motion for adequate cause.
Yeah.
So I wasn't supposed to serve that. I was supposed to do the summons.
Well, you have to serve that as well, but you have to serve the initial documents. And I have no service of the initial documents. I don't have jurisdiction. Even if I were to enter orders, they would be void. They're not proper because he's not before the court. You haven't invoked the court's jurisdiction because you haven't served him with the underlying documents.
What are the underlying documents?
I can't give you legal advice.
Okay.
Not that I don't want to, I'm prohibited from doing so. I can tell you why I'm doing what I'm doing. So you have to serve a summons and petition that invokes the court's jurisdiction. You sent it to the sheriffs to have service of that done. They did their return of service indicating they did not serve him. They could not find him. They could not serve him with that. That was done back in March.
Okay.
You then sent the sheriff's office in May a motion for adequate cause and this note up slip for today, and they served that on him.
But you can't do nothing without the other part?
Can't do anything without the other part.
Okay.
So.
And what about the termination of the guardianship? Do I have to just do that one?
Yeah. Those are heard in the morning. They're at 9. Guardianships are
Okay,
at 9.
yeah, that's not what they told me. They told me that it was at 1 with the other one, with the other case as well.
But
I even asked them twice. Okay.
so, but again, you have to kind of deal with, we have to deal with that one and this one kind of at the same time because they're related cases. That guardianship superseded this case, and until, you have to deal with the guardianship. If it's going to get dismissed, we have to have something in that case.
All right.
So, okay. All right. The Earl and Hunt matter, 21-3-413-13. Can you state your name for the record, sir?
Josh Earl.
Okay, you're going to be seated. And ma'am?
Taylor Hunt.
Okay. So you guys didn't go to law school?
No.
Which is fine. It's just procedurally, I'm assuming, we know what assuming does, but I'm assuming that you expect to have there be some sort of trial today.
Wasn't really going for that. There was just a couple of things I wanted to ask for.
Well, you see, and that's the whole thing. So this isn't the forum to do that. You filed you gave him a notice to relocate and not until 2026. And then, sir, you filed an objection.
Yes.
And that starts the case, and you filed the response. And so there are 3 ways out of this case. Well, for you guys, probably only 2. You can either reach an agreement, okay, and reach an agreement. Then you come in like the other people did, and you just hand up agreed documents. And maybe you don't get it all filled out right and have to send you away for a week or 2, and you get the corrections made, but it's all agreed. You guys are in agreement. Whether you get it reduced to proper writing, for legal purposes, that might take you a little bit, but you reach an agreement. That's option 1. Option 2 is you have a trial. Okay? There'll be a trial, but to have a trial, you have to go to mediation first or get mediation waived. Mediation's only waived for good cause. That's if there's like DV between the 2 of you and
I
you
have
have
set up mediation before. I made the appointment. She canceled it because she couldn't afford it.
So you guys are going to have to go to mediation. You go to County Basin Dispute Resolution Center. They do it on a sliding scale all the way to free, so but you have to go to mediation. I can compel mediation if you guys aren't able to agree to mediate, but there's a local rule for mandatory mediation. You must mediate unless you come in and ask for a waiver for good cause. Thinking you won't reach an agreement is not good cause. Not wanting to do mediation is not good cause. Good cause is if you guys have restraining orders against each other and you can't be in the same location, or, she assaulted you with a car and ran you over and it creates problems, but these would probably be restraining orders anyway in those, but it has to be something like that. So the third way is you can get back together again but like I said, that's probably not the case. That's for when they're divorcing. You got 3 ways of resolving it. You either reach an agreement, you have a trial, or you get back together. This isn't a relocation. I think that ship sailed because I think you're both remarried. So in any event.
I'm wondering, just because of everything, if there's a way to look at the issue with the current parenting plan and find a way for us to be able to meet that is good for both of us. Because for the last year, I've been doing all the driving in order to get the children. And so I'm trying to see if there's a median spot that we can go to that's, in place by the court.
Nothing's, I mean, what is the parenting plan? You have to follow the parenting plan unless you agree otherwise.
Can I say something real
Yeah,
quick? So
sure.
a year ago, we moved to Yakima from Moses Lake. I filed a motion to move then. And he never filed an objection to that.
Okay.
And I didn't understand that I was supposed to come back in and file like an ex parte or whatever it was. But in that proposed parenting plan, it says we're supposed to meet in Ellensburg. The technical halfway point is a rest stop, but neither one of us can get to from either side. So I chose McDonald's, Ellensburg.
Okay.
But the problem with that is I drive that a lot for my work, and Ellensburg is maybe a 25, 30-minute drive. I drive it from Ellensburg to Yakima, it's 30 minutes. So you're still going to have me do almost all the driving. That's where I'm kind of...
So there's a couple. It's really not before the court, but if you guys are in agreement, I mean, there's more than one way to skin a cat. I got a lot of cliches. My kids make fun of me for cliches, but there's more than one way to skin a cat. So if you want to really meet halfway rather than meeting halfway, is you drive all the way to Yakima to pick up the kids. You drive all the way to wherever you live.
And that was something...
Is that Ephrata or Quincy or Moses? Okay.
That was something that I had offered.
So is there an issue with that?
So the current car that I'm able to drive it will not make the hills. So I'm having to now, because this became a problem when I filed, I'm having to ask a friend to drive to Ellensburg to be able to drop the kids off for his scheduled time. I cannot always go to Moses Lake constantly because it's not my vehicle. And I'm not able to purchase a vehicle that can climb Monastash Hills or Vantage Hills.
Ryegrass. Yeah. I know. You have the other side of Rattlesnake Ridge and coming up out of Yakima. And then you have,
and that's where I'm having issues with my car, but mine's in the shop right now. So hopefully soon I'll be fine. But I'm just trying to find like a happy median. Like I understand their car issues and, that's why I drove for the last year to get the kids. I want to see our children, I don't want to, but I've also had car issues going back and forth. So I was like, I'll meet Advantage.
So, ma'am, what do you propose?
I do.
So let me say one thing. There's two parts to travel. One is the logistics, who actually travels, and the other is the cost, who pays the cost. Now, if somebody, if you each travel halfway, logistically you're doing half, and cost-wise you're doing half because you're each incurring the cost of your own vehicle and gas and everything to go to the halfway point. So is the issue, sir, cost, or is the issue time? If it's cost, that can be addressed.
Right now, it's cost because of having to go up there, but also wear and tear on my vehicle.
That's cost. It's all cost related.
It would be cost related because I'm not making what I used to make.
So, ma'am, and the issue with you is more logistics than cost, correct?
Not necessarily.
Okay.
I'm not able to. I can pay to meet for gas in Ellensburg. I did Ellensburg because that way we're both going up very steep hills. We're both having to incur costs of wear and tear on our vehicles. My current vehicle cannot mechanically make those hills. That's why I opted for getting a ride now. That's the whole reason why I chose Ellensburg. So one person's not having to go.
Okay, that's fine. What is the distance from your house to Ellensburg, roughly? I know about what it is. I don't know where you live in Yakima.
It is about I want to say 45-minute drive from my house. or so.
Not minutes. Is it 30 miles? Is it 40 miles?
I don't.
Where do you live in
I live in
Yakima?
West Valley, Yakima.
West Valley?
Yeah, West Valley.
So it's a little further out there. So how far is it from Moses Lake to Ellensburg?
To Ellensburg, I want to say it's about an hour.
Again, okay, Ellensburg, it's exit 110 at the second exit where all the restaurants are, that's exit 110.
Yes.
Moses Lake is exit 176 or 179, depending which one you get on, right? Is that? I think it's 179 at the far end and then 176, the Best Western. Okay, so it's like 65 miles plus whatever. So 70 miles for you to Ellensburg, and ma'am, you're like probably 35, maybe 40 miles.
Yeah.
40 miles.
Yep.
So 40 minus, 65, 179 to 110, or 70 miles. So, okay. What are you guys wanting? I mean, is this just a money issue that needs to be addressed in child support, a credit for dad driving extra to?
I'm getting my vehicle fixed on, so I will be able to go up there, and it was more just a money issue because, it was half tank there, half tank back every weekend that I would get the kit. So that's $100 every single time I have the kit.
That's fine, but you're not worried about that now?
No, it's just
okay. Then the other option is, does Kittitas work better? Kittitas is another 10 miles, 8 miles, whatever.
Meet at the Shell.
Yeah.
Does that work?
Yes, that
All right. That work for you, sir?
Yes.
All right. Meet at Kittitas.
Okay.
The Shell there, is that where they have the Philly cheesesteaks or whatever?
Yes.
See on the ad as you go by? Okay.
Yep.
All right. So you'll meet there. No one's requesting an emergency move, and no one's requesting an emergency restraining of a move.
No.
You're not moving until 2026.
Mm-hmm.
It's to Mississippi.
Mm-hmm.
That's a big move.
Mm-hmm.
You guys need to get to mediation. Mediation needs to occur. You might be able to reach an agreement. Maybe you won't. I know there's no compromise, like you're not going to move to Denver. That's halfway between Washington and Mississippi, or maybe Kansas, wherever halfway is. That's a little different. It doesn't work so much that way, that type of a compromise, but you guys might be able to reach an agreement, on, I don't know, sir, if you're objecting to the amount of, time and you get more time and other time. I mean, you're just going to have to see.
Having more time was fine with me, and the only reason that I put in for full custody was it was more just like a temporary order until they can get on their feet over in Mississippi, because I didn't want them going over there half-cocked, no job, no real place to stay, and then figure it out over there.
Okay. So you're not necessarily
Not saying
opposed?
that I want to have the kids
Okay.
and take them completely away from her. That was not what my intent was.
So at mediation, you guys might have something to discuss and see if there's some form of a compromise that can be reached. Get to mediation. If you reach an agreement, it can just get entered. Okay. If you don't reach an agreement, you're going to have a trial, and you have to do mediation, and then there'll be a trial, and then you'll get sworn in.
It would have to go through mediation.
Yes, you have to go through mediation first. You'll go to mediation, ma'am?
Yeah. If it's just, I can't afford $500 right now to pay for mediation.
Columbia Basin Dispute Resolution Center. So you can do mediation with an attorney, and it's going to cost $500 or $1,000.
Right.
They do good jobs. They know a little more, but you can also do the Columbia Basin Dispute Resolution Center. They got the little orange, if you go out to the little turnstile thing, they got their orange, it says CBDRC or whatnot. You can also look it up online. They're over here on Basin Street, a couple blocks, and they do it on a sliding fee scale. It will cost less all the way up to free, depending on the party's incomes. You might have to pay a little more, you might have to pay a little less. If you make more, you're going to pay a little more, but it'll still be less than an attorney, and you will pay less if you make less. But they will do the mediation, and you guys have to mediate in good faith. I'd love to order you to reach an agreement. I can't. I'd like to, but I can order you to mediate in good faith, meaning you have to just listen and try to compromise and get somewhere. But at the end of the day, if you don't reach an agreement, then we'll have a trial, and either the move will be allowed. Well, you can't be restrained from moving, but the kids moving with you would be restrained or allowed, and what form of a parenting plan it would take. But if you guys can reach some agreement, then great. People tend to like the deals they reach themselves rather than having them imposed upon them. Yeah. I will only hear part of a day's testimony from you guys and then render a decision. You guys have lived your lives. If you're able to reach an agreement, you can fine tune it. The court's going to take the facts and apply the facts to the law as I find them and issue a decision, but I'm not going to know all your intimate details of your life and your child's life and how things interact. I mean, I don't know that. I'm going to hear from each of you and maybe a witness or two others. So, okay. I'll strike today's hearing because there's really nothing. It's not for a temporary move or anything like that or to restrain anything. Okay. Meet in Kittitas. Okay. Okay. Anything else? Okay. Get to mediation. See about an agreement.
Okay.
All right, thanks. All right, the Cook matter, Karina Cook and Jeffrey Wadston, 20-3, 26-13. Is Jeffrey Wadston present? Jeffrey Wadston. *6 to unmute on the phone, unmute button on the upper computer. Last call, Jeffrey Wadston. Ma'am, can you state your name for the record?
Karina Cook.
You're the mom?
Yes.
All right. So have you had any contact with Mr. Wadston? Has he given you an answer, a response to your petition?
No, and my attorney also said as of this morning, she hasn't got anything either.
Okay. So this was on 3 weeks ago for default. The dad appeared.
Yeah.
And so I set it out 3 weeks at dad's request so he could get counsel or respond. He has not filed anything. The last thing in the court file is the minute sheet from that hearing back on May 9th. And you haven't received a response from him, and neither has your attorney?
Nothing yet.
Okay, he's not here. So I will find him in default. I set it over. I told him he had to get a response in, or at least appear. He hasn't he's not appearing today, and he has not put in any response. So if he was here, I would set it out maybe one final time. I know there's a ongoing dependency, so there's no emergency. But he's not here, and he had notice of that hearing. So I will find him in default. Do you have orders?
What do you mean by orders?
An order of default?
The one I filed with you last time is, I didn't do another one. Should I have done another one?
Well, I just need an order of default. So I wasn't sure if you had one. I can't take the one there's the motion for default. I can print out, because it was filed as proposed. I can print it out and sign that. And are you wanting the final order and findings and all those materials entered?
Yes.
Okay. Are there you didn't make any material changes to the documents? It's the same parenting plan that you filed?
Yes.
Is the one that you have as your proposed final parenting plan?
Yep.
Okay. All right. I will print those out. They're at subdocument 24. I can print those out and I will sign them since he's not here. So, and hasn't put in a response. All right.
I have a question.
Yeah.
We didn't do a thing of child support. Should I have done a child support one or?
Well, I don't think there was child support. You didn't ask for that.
No, because I don't know if I was supposed to or not.
Well, you can check with your attorney on that. I can't give you legal advice.
Okay.
I can sign, you wanted a parenting plan, and the final order and findings, and that's all consistent, I will sign that. You didn't ask for child support, I can't, and nothing's been filed, he doesn't have notice of it, but you can talk to your attorney about that.
Okay,
Okay, all right, thanks.
thank you.
We got the Darracott matter, 12-3, 492-7, Darracott and Holmes. Is Justin Darracott or Ashley Holmes present?
Yes, Your Honor.
Okay, what's your name, ma'am?
Ashley Holmes?
Okay, and you're the mother?
Yes.
Okay, is Justin Darracott present?
Yes, Your Honor.
All right. Preliminarily, so ma'am, you didn't file, your material wasn't filed under penalty of perjury? You just have a statement that's not on a declaration format?
I thought I had to do the paperwork I just filed a couple weeks ago.
Yeah, and your declaration just says, it's on a letter sheet from you to whom it may concern.
Oh,
and,
yeah.
And it's not under penalty of perjury or anything.
Okay.
And you haven't filed any other documents, no other declarations. So I just wanted to find out, and sir, you haven't filed a response to
That's correct,
the
Your
adequate
Honor.
cause? Is there a reason?
I've just been really busy and I haven't had time to send it into the court yet.
Okay. So how long is it going to take you to get a response in?
I could have it done within a week.
Okay, and ma'am, you need to correct the deficiency and make the declaration under penalty of perjury. And was there anything else? I mean, that's the only thing I have from you.
So the parenting plan that I filed.
Well, I have the parenting plan, but a basis in order to, there has to be a factual basis. I just have to, what's the facts? You guys aren't going to testify. This is testifying in writing. Adequate cause is a threshold hearing where the parties put their testimony in writing, and then the court, they can argue, they can try to convince the court why I should do what you want me to do, but you don't testify. There's no new materials. It's not oral testimony, it's written testimony. So if you're fine with that declaration, it needs to be under penalty of perjury, but I can set it out a few weeks for Mr. Darracott to get his materials in and for you to reply to that. But I just want to make certain, is there anything else you want in first?
Yeah, I probably would write another declaration under penalty of perjury.
Okay, so how much time is it going to take you to get that done? And any other declarations, you can't do it piecemeal. If you have anything else, you need to get all your initial stuff in, and then Mr. Darracott responds to it, and then you get a brief reply. If there's something new that he raised, you can reply to that, and that's it. But you guys do this in writing. So do you, how much time do you need to get any declarations need to be under penalty of perjury? I have your proposed parenting plan. I have that. But I just meant actual testimony.
Okay, so that would probably just take me a week.
Okay.
But the thing is, starting July 1st, I'm going to Big Bend for my CDL. And I don't know if I won't be able to miss. So I don't know how to go about that.
Okay. Well, Big Bend's a 4-day-a-week college. They don't have classes on Friday.
It's 5 days a week.
Oh, for that?
CDL. Yeah.
Just for that, because there are other colleges and it's still 4 days a week for physics and English and all that stuff.
Yeah, it's let me look real quick. It's Monday through Friday, 7:30 to 4:30.
Okay. Well, I I mean, if you want to put this out further, I don't know when it's over with, or we have to do it before, we can do it the end of June.
I think the end of June would be all right. It's up to Justin.
Okay, I can set it out to the 27th.
Yeah, I'm okay with that, Your Honor.
Okay, I'll set it to Friday, the 27th of June. Ms. Derricott, you need to get anything that you want considered needs to be under penalty of perjury, your declaration, declarations of others, if there are any. They need to be filed and given to Mr. Derricott. Then Mr. Derricott, you can respond with your declaration and any others if there's other people, you know, and then you'll get a brief reply. We'll have the hearing on the 27th, but you need to get it in. Okay?
Okay, thank you.
Okay, Mr. Derricott, anything else from you?
No, that's all. Thank you, Your Honor.
Okay, thanks. All right. And is Liz coming back?
No.
No, okay, I was gonna say, because you're fine, I can either, we can take a short break or we can do the Thompson. All right, let's, we just, what's that other one?
I don't know. Salinas versus Cabrera.
Oh, that's file 2, that's an extra file, we had file 3. So that was just an extra file. All right, let's call the Thompson matters. We've got Adam and Tanya Thompson, 21-3, 384-13, and 25-2, 435-13. So, Mr. Thompson, can you state your name for the record?
Adam Thompson.
All right, and Miss Thompson, can you state your name for the record?
Tanya Thompson.
All right, so we're here on 2 things. We've got a contempt issue in the 21-3 case, and then there's a restraining order case, 25-2. It was set over to this docket by, I think, Judge Clarkson. So I guess I need to find out. I didn't get any sort of additional response or any sort of materials from you, Mr. Thompson, in the 2 case. What's the status of that? Are you wanting to put in materials? Is that case going to be contested or not?
Your Honor, at this point, I just want to do whatever app that Tanya wants to agree to as far as our communication back and forth about our children. I'm willing to drop this. She's willing to drop the restraining order. I'm sitting here in jail right now on a technicality of not including my son's name in a text message that did definitely have to do with him and his well-being. I'm willing to just drop it all, okay? I need to get back to work. I need to see my children. I've been in jail for a week on a single word that I did not include in a text message. I apologize to the court. I don't want this stress anymore. I just had somebody in the tank tell me that I look 15 years older than I actually am, which is exactly the opposite of what everybody always tells me is I look, 10 years younger than I always am, and I'm just done with the turmoil, the strife. Give me my time with my children. Leave me alone. I'll give you your time with the children. I'll leave you alone. Just make sure that my children are safe. Please.
Okay. Ms. Thompson?
Yes, Your Honor.
What are we doing today?
I just wanted, for the record, I was following the parenting plan. I don't feel that this contempt is right. Per the protection order, so he can speak to his children, because as of right now with it is not allowing us to do home wave, so he can, because of the protection order. So that's fine. If I just wanted to address with the court with the no more harassing, and when he does get out, if it can be under Family Wizard app, if
That's
possible. I just don't know how I'm going to pay for it because it's $100 and something.
I'll pay for it. I'll pay for it.
Okay. So is there so Ms. Thompson, are you wanting to dismiss the protection order, the 25-435 case? And Mr. Thompson, are you wanting to dismiss, withdraw the contempt issue? And the parties want to, Mr. Thompson, you're willing to pay for the Our Family Wizarding app, and Ms. Thompson, you want Our Family Wizarding app, and that's how you communicate is through Our Family Wizarding app, limited to just the kids. I know Our Family Wizarding app, you can't delete texts and stuff. It's saved there, you know. One side can't delete stuff, but is that what everyone's wanting? So, Ms. Thompson?
Yes.
To get back
Yes, Your Honor.
See my children again.
Okay, so let me just make sure here. So, Ms. Thompson, you're wanting to drop the 25-435-13, the restraining order case. That would just be dismissed. Mr. Thompson, you're wanting to dismiss the contempt action.
Yes.
And you're wanting me to enter an order that says the parties will communicate in the 3 case, enter an order that says the parties will communicate via Our Family Wizarding app only, limit it to, you know, issues about the children. And when Mr. Thompson will pay for the Our Family Wizarding app on an annual basis, you know, you'll pay, I think there's a discount when you do it annually. It's like $10 a month, or it might be $60 or $70 for the year if you do a year, but you'll pay for that for both of you.
Yes.
Okay. Ms. Thompson, is that
Can
accurate?
I have my children for a weekend that I missed out on this weekend?
Hold on. Ms. Thompson, you're in agreement with that?
Yes, Your Honor.
Okay, and Mr. Thompson, you're in agreement with that?
Yes.
Okay. Now, what I can do is this, and I want to make certain what this does is there won't be any contempt, you know, and Mr. Thompson, I can dismiss the the protection order case. The criminal case has that's its own thing. You guys have to deal with that. But
I'm sorry, you're on a criminal case. Explain to me, please.
I'm assuming you're being held on a criminal charge of violation of a protection order, right?
Yes.
And so while I can dismiss the protection order case, that doesn't dismiss the criminal charge. That'll be between you guys and the prosecutor. I mean, it dismisses the protection order so that it's no longer effective in the future.
Can we discuss this right now, Your Honor, then, please?
No, because I'm not a party. That's a different case. That's a one case, and that's the prosecutor.
I'm talking about, can Tanya and I discuss this right now in front of you? Can you please go ask the prosecutor to dismiss this, Tanya, please?
So, sir, you can't. Ms. Thompson has to talk to the prosecutor if she wants to. She can, but it's not appropriate. It's a state case, so I just wanted to be clear about that. So, all right, what the court can do, I can sign a dismissal of the protection order.
Is there any way that you can request a reduction in bail at least?
Well, what you have to see, sir, that's in the criminal case. That one case is different. You have a public defender for that. You can talk to your public defender.
No, there's nothing on that. They had Judge Hill come in to do public defense for us on the arraignment. They didn't have a public defender to come in and represent us.
No, but you're going to have a public defender. You would have got appointed one, and so you can talk to your public defender about that. It's the same thing, because I know you had one of these before. You know, it's the same type of process.
One of what?
Didn't you have a protection order violation? from
Not-
earlier? No?
Not,
Okay.
no, that's all still on the table, and that's I'm going to be going to community court to get all of this resolved.
Okay. Well, yeah, I don't know. I'm just saying that any criminal, the only things before me is this protection order, and that I can, so that there can't be further violations if it's dismissed. So,
and can you send something, Your Honor, to the court or to the jailhouse so he can have home wave with his children? Because that, as right now, the protection order is the only thing keeping that.
yeah, the protection order will be dismissed. So then that will clear that.
Okay.
So I'm dismissing it right now. Protected person appeared in person. Nope. Video. Wrong one. The restrained person appeared by video. All right.
And then I just come before you if he violates and harasses me further. Do I come before you, or do I put on another protection order? Because I don't want to upset you, but that was the only way I knew how to do it. So I don't know if I come before you or if I do that.
I'm not going to talk to you at all.
If he violates.
So if there's, I can't give you legal advice, ma'am. If there's a violation of a family law order, then, yes, you can come before the court on contempt. If it rises to some level of a anti-harassment protection order, that's a different case. It's a different matter. So, let's see. Final order findings, requested dismissal of the petition. I'm filling this out right now. Order, final order dismissed, was asked to terminate and appeared. All right, service on the restrained person not required. No further court hearings are scheduled. I am signing the order. This dismisses the protection order as of now. The protection order is no longer effective. So that will, if that's what was causing a problem with the home wave, with the visits at the jail with the child, then that will lift that. 3:25 p.m., 5/30/2025. I'll get that right to the clerk. And then on the 3 case, I need a blank order here. I will fill out the blank order. It will say, all right. It is ordered that the contempt filed by father on, it was filed on May 8th, 2025, is hereby dismissed with prejudice, can't be refiled for that particular issue. Additionally, that's 1. 2, the parties will communicate exclusively with our family wizarding.
And Your Honor, I'm still being held, and the only way that I'm able to talk to my children is through the phone on the wall here, and I just.
So it won't be able to be through Family Wizard while he's incarcerated. That will have to be while he's out.
No, I understand. I mean, this just means that Mr. Thompson and Miss Thompson will communicate exclusively with our family wizarding app. You can you can communicate with the kids separately and differently. And yes, sir, I did sign the dismissal, the protection order. If that was what was causing problems with talking to your kids while you're in jail, that will remedy this. If once you're out, then you can have the visitation. I mean, all that stuff. I will put Mr. Thompson will pay for both parents, our family wizarding app accounts. Now, obviously, that will have to wait until you're out, and then you can pay for that. I'm signing this order. So the contempt is dismissed.
What about my makeup time, Your Honor?
Pardon me?
My makeup time for this weekend and possibly, next weekend. I don't know.
So
can I please have time, Tanya? They arrested me right in front of Adam, Tanya.
So, Ms. Thompson, are you fine with him having, when he gets out, a little extra time or what?
How about we just take off the makeup time that's already imposed on me?
That's fine.
Okay. You're fine with that, Ms. Thompson? You want me to,
Yes.
I can put 3 down as the makeup time in the previous order is hereby withdrawn and satisfied?
Yes, Your Honor.
Okay. Let me see. That order was entered on May 16th. All right. Number 3. The makeup time for Miss Thompson in the contempt order dated May 16th, 2025 is hereby satisfied and completed. All right. Okay. Anything else?
No, and he can contact me when he gets out to see the children.
Okay.
For a few hours if you'd like. So that's fine.
A few hours?
Now, I said, we'll discuss when you get out. I don't know when you will get out, so we'll discuss it when you get out, but I'm not gonna keep them from you if it's my parenting time longer. I'm just stating, we'll just talk about.
Okay, so if you get out and it's your time, Mr. Thompson, then you'll get the kids. If it's Miss Thompson's time, when you get out, send her the message, get our Family Wizarding app, talk to her, and it sounds like she'll help accommodate and facilitate some extra time there until it's your time, and then you'll be back into the normal routine. And hopefully there won't be any further. I hope I don't have to see you guys again. I know you probably don't want to see me, so I do wish you the best of luck. That when you're out, that hopefully you guys with our Family Wizarding app and everything, and I know you've been through a lot, hopefully you guys will be able to just co-parent and not be back in court. Not that I don't mind seeing you guys, but I'm sure you don't want to see me, and you have better things to do than spend your Fridays, dealing with court. So.
Or a whole week in jail over not including my son's name in a text.
Yeah. So I've signed the denial order. I've signed the order that set out the contempt's dismissed and the parties use our Family Wizarding app, and the makeup time from Ms. Thompson is satisfied. All right. That's, I think, all that's before the court right now. So that's it. Anything else from you, Mr. Thompson?
No, sir.
Anything else from you, Ms. Thompson?
No, thank you, Your Honor.
Okay. I would point out to both of you that this is the most civil you have both been in a long time with each other. You should be commended at least for that. You are both being very civil with each other and and compassionate with each other, at least at today's hearing. Hopefully that will continue.
Your Honor, I would like to
I do
point,
notice that. So, okay.
now, I'm just gonna shut my mouth.
Okay, yeah, you guys have, I'm giving you a compliment, both of you. You're both being really good. So I wanted to note that, I acknowledge that. So, all right, that's all the cases the court has. Does anyone have a matter that was on the docket and wasn't called? Nope. All right, we'll be in recess, and Mr. Thompson, you can let the jail staff know that your case is over with.